Much for tuning in to our online event entitled Appreciation on Committee on Decorum and Investigation, Anti-Sexual Harassment Act, and Safe Spaces Act. I am Queenie Pearl V. Tomorrow, a faculty at the Department of Political Science, College of Arts and Social Sciences of Mindanao State University, Iligan Institute of Technology, and I am your moderator for today's discussion. To formally begin, I invite everyone to take a moment of silence for a quick prayer. Good afternoon once again. Today is day one of a two-part learning and development program. And this online program is focused on learning and development, specifically on the engagement in gender and development. Two areas of focus in this learning and development program are the two Republic Acts, namely RA 7877 or Anti-Sexual Harassment Act and RA 11313 or Safe Spaces Act. The objectives of this training program are the following. Firstly, for the participants to apply the concepts of decorum and investigation. Secondly, to implement or strengthen the Committee on Decorum and Investigation in their own HEI or agency. And thirdly, to generate the implementing rules and regulation of Sexual Harassment Act and Safe Spaces Act for their own school or agency through your office manuals and records. So this training program is organized by the Commission on Higher Education of Region 10, specifically its HR office and GAD office. It is sponsored by the Gender and Development Resource Center of Mindanao State University, Iligan Institute of Technology. Before we proceed, I'd like to inform everyone joining us in the Zoom room that this session is also live streamed on the Facebook page Gender and Development Resource Center, MSU-Iligan Institute of Technology. So there are a number of people joining us on Facebook. And so a few reminders in the Zoom meeting to observe proper etiquette. Firstly, kindly mute yourself when the session is ongoing. Secondly, to optimize your bandwidth usage, we are requesting you to turn off your cameras. Cameras are encouraged to be turned on only after the discussion, specifically during the photo opportunity. And lastly, if you are in the Zoom meeting, kindly change your Zoom account name to your organization and your complete name for easy recognition. At this point, let me hand you over to the Chancellor of Mindanao State University, Iligan Institute of Technology, Dr. Sukarno D. Tanggol, for his special message. Dr. Tanggol, good afternoon, sir.
Thank you, Queenie. Our Honorable Commissioner Aldrin Darilag, Director Dr. Raul Alvarez, officials from CHED, Natalie Igot and company, of course, Attorney Eric Peralta, our resource person, MSU-IIT officials headed by Dr. Bornales, Queenie and JP, magandang hapon po sa inyo lahat. I am honored, despite my busy schedule, to be here with you on a very important topic. Let me first mention a few quotes. As a Muslim, I think some of you might be surprised for these statements that I have to make. It was said, and I quote, "Paradise lies at the feet of your mothers." So that is how important women are. The Prophet said so. Also this morning, I was scouring the chat groups and I read somewhere which says, a good man treats women with honor. And I don't know if you know that there is a higher reverence for Virgin Mary in the Al-Quran. There is a whole chapter there entitled Mary. And we also believe as Muslims in the Immaculate Conception of Mary. And finally, about more than 14 years ago, I think while the West is talking about equality to women and men, women in Islam were already given the right to education like that of men. They were given the right to own property, even wealth. And in fact, it is said that the property of your husbands, the wives have automatic right over it, while it is not vice versa. The property of a wife, the husband has no right over that. And also, women in Islam have the right to maintain their maiden names even if they're married. Having said that, I remember I once spoke at an ASEAN conference where I was happy to note that in MSU-IIT, there's quite no issue with women. In fact, I said that if you look at the school, there are more women faculty members, more women staff, more women students, more women chairs of the various departments. And at that time, there were equal numbers of deans, men and women. And I think, JP, you will agree with me that there are more directors who are women. And as far as vice chancellors are concerned, there are 2, while 3 are men. And I look forward to having a female chancellor also in the future. Having said that, let me finally say that in terms of the CODI, MSU-IIT is quite very serious in trying to organize and institutionalize our CODI. This is very important in schools, in HEIs. I think per our experience here, there is hesitancy on the part of the students to complain because they need the assurance from administrators that they can bank on the support of the administration in pursuing especially cases against faculty members. Many a times we ask students to really pursue their cases, but they were only after the need to graduate because also they were afraid of their faculty members going after them that might disturb their goal of graduation. And so in MSU-IIT, we have a woman who heads our CODI right now. And I would suggest so also for HEIs and even other government organizations that their CODI be headed by women, because I think it is in their hearts that the sexual harassment or women's rights be respected fully by the government and their instrumentalities. So let me welcome again all of you, and I am sure that you will have a very fruitful listening to our speakers, especially Attorney Peralta on God. Again, thank you very much for having me this afternoon. Thank you. Back to you.
Thank you so much, Dr. Tanggol, for gracing us with your presence, for the insights that you shared, and for the warm welcome as well. We also have here Director Raul C. Alvarez, who will also give a special message. Director Alvarez, over to you, sir.
Thank you, Queenie. At the onset, allow me to manifest my gratitude to the good Commissioner Aldrin Darilag, the oversight for gender development of the Commission, Sir, daghang salamat for taking time, no? Si Sir taga Mindanao man eh. And of course, the Chancellor of MSU-IIT, Dr. Sukarno Tanggol. Doc, daghang salamat sa pagpahulam sa imong facilities, no? Sa atog mga MCs and our resource persons. Okay? Thank you, Doc. And also, foremost, I would like to thank in advance our very able resource person for this afternoon, Attorney Eric Paul Peralta. Attorney, thank you for heeding the call of sharing your thoughts niya, no? Mamaya sa lahat ng mga issues to our, of course, our private HEIs are here. Our state universities are also represented, and even our local colleges, no? So also, I would like to thank the God focals again of our HEIs in the region, especially our, I see even Tubod College, no, represented down in Lanao. I see our HEIs from Bukidnon, and also USTP is around, and even God TC, no, one of our leading local colleges. Daghang salamat sa inyong presence, no, and we hope together with Ma'am Nats here and Dr. Fuentes and the rest of the CHEDRO officials that this will be a very fruitful engagement for you. We hope that you could further the programs for gender development in your respective HEIs. And by the way, we have awarded as Dr. Tanggol, of course, and MSU-IIT as a model HEI for our gender development programs, no? So pwede jud mo mag-benchmark dito sa MSU-IIT later, no? I don't think Dr. Tanggol will deny you the privilege of helping you out go through with your systems for gender development, including your processes. And as such, without further ado, I again would like to thank all of you for coming this afternoon. I hope we will leave the day, again, more knowledgeable, more gender friendly, and able to participate in all the gender development activities of our respective HEIs and further gender development in our society. Daghang salamat, maayong hapon ka natong tanan.
Thank you so much, Director Alvarez. Maayong hapon po, sir. And thank you most especially for leading the implementation of this very important learning program. At this point, we'll listen to the Commissioner Oversight for GAD from the Commission on Higher Education, Commissioner Aldrin A. Darilag. He will also be giving his inspirational message. Commissioner Darilag, good afternoon, sir.
Good afternoon, Dr. Raul C. Alvarez Jr., the Regional Director of CHED Regional Office 10, Attorney Septon A. de la Cruz, Chairperson of the GAD Focal Committee of the Commission, Dr. Sukarno D. Tanggol, the Chancellor of the Mindanao State University Iligan Institute of Technology, or the MSU-IIT, Attorney Eric Paul Peralta, the Director of the University of the Philippines Los Baños Gender Center and a National Gender Resource Pool of the Philippine Commission on Women, Presidents and Vice Presidents of the higher education institutions in Region 10, Deans, members of the Committee on Decorum and Investigation from the state universities and colleges and local colleges, student affairs directors, GAD focal persons from private and public higher education institutions of Region 10, CHED Regional 10 GAD Focal Point System and personnel, faculty, non-teaching staff, participants in today's event, ladies and gentlemen, good afternoon. I extend my commendations to the CHED Regional Office 10 for successfully organizing this event. As part of our efforts of gender mainstreaming in the Commission and being the Oversight Commissioner on Gender and Development, it is my commitment to guarantee that our educational system serves as a safe space against gender-based sexual harassment and discrimination, and that the heads of these institutions provide accountability in its awareness campaigns and practices for a more gender-inclusive environment. As an outcome, our educational institutions will develop holistically and provide a suitable and safe environment for our teachers and students, regardless of sexual orientation and gender preference. Republic Act 7877, also known as the Anti-Sexual Harassment Act of 1995, is a legislation wherein the state recognizes and guarantees full respect for human rights, upholds the dignity of workers, employees, applicants for employment, and students, and the development of human resources to ensure that all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful. Work, education, or training-related sexual harassment is committed by someone with authority, influence, or moral ascendancy over another in a work, training, or educational environment. Sexual harassment may be in a form of demand, request, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted by the object of the said act. Under Republic Act number 8788, a work-related or employment environment, sexual harassment is committed when first, a sexual favor is made as a condition of hiring, rehiring, or continued employment of an individual, or granting or in granting compensation or promotion, or the refusal to grant the sexual favor, resulting to limited opportunities for the employee which adversely affect the employee. Second, the acts mentioned would impair the rights and privileges of the employee under the labor law. And third, the acts mentioned would result in an intimidating, hostile, or offensive environment for the employee. While in an education or training environment, sexual harassment is committed against a person who is under the supervision of the offender, against a person whose education or training is entrusted to the offender, when the sexual favor is made a condition to the giving of a passing grade or the granting of honors and scholarship and other privileges, or when the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. Pursuant to the Civil Service Commission Resolution number 1-0940, or the Administrative Disciplinary Rules on Sexual Harassment Cases, one of the salient provision is the creation of the Committee on Decorum and Investigation, or CODI, in all government agencies. The committee is responsible for receiving and investigating sexual harassment complaints and conduct meetings with officers, employees, teachers, instructors, professors, and students to increase their understanding and prevent incidents of sexual harassment. Capacity building programs were designed for those who will conduct training programs on the anti-sexual harassment rules and policies. As part of the growing initiative of the Commission, the CHED Memorandum Order number 1, Series of 2015, established policies and guidelines on gender and development on CHED and higher education institutions. Gender mainstreaming, one of the major strategies to recognize the rights of women and men, will be utilized for a more informed members of society. In addition, establishment of GFPS, or the God Focal Point System on private higher education institutions, state universities and colleges, and local universities and colleges contributes to a more cohesive approach in gender mainstreaming. Through this, policy formulation and implementation will be systematic, and higher education institutions will promote gender-responsive curriculum programs that will prevent all forms of gender-based discrimination in the institution. Consequently, the program will advocate gender equality and women's empowerment through the provision, availability, and accessibility of opportunities, services, and observance of human rights, which enable women to actively participate and contribute to the political, economic, social, and cultural development of the nation. As a policy-making body, CHED stands up together with our learners, teachers, researchers, community members, and policymakers so that our higher education institutions truly become agents of inclusion. The Commission ensures that education transforms society better. Some of the noteworthy initiatives of the Commission regarding this movement include: first, the development of specific education policies anchored on the Republic Act 11313 or the Safe Spaces Act to require all higher education institutions to educate their students and train their faculty and inform them as to how sexual harassment ends in schools. Second, the creation of the Technical Panel for Gender and Women's Studies to enhance the policy standards and guidelines for the gender studies curriculum at the graduate level. Third, continuous conduct of gender sensitivity training among CHED employees. Fourth, the establishment of Gender and Development Focal Committee in the CHED Central Office as well as in the CHED regional offices. Fifth, the establishment of a GAD unit who will focus on GAD-related concerns within the Commission as well as with its partner institutions. And lastly, continuous capacity building for GAD focal persons on GAD planning and budgeting, use of assessment tools such as harmonized gender and development guidelines, gender mainstreaming and evaluation framework or the GMEF, and the gender mainstreaming monitoring system or the GMMS. The CHED Region Office 9, through the leadership of Director Rodi Garcia, developed a system called Philippine Higher Education Gender and Development Data Information System, or the PEGADIS portal. The system is a centralized approach on the collation of demographics and the sex disaggregated data from higher education institutions. It will facilitate a comprehensive policies and framework on program implementations. For wider dissemination to the public, the website will also house research, teaching, and learning materials on GAD and the achievements of the Commission on GAD as well, such as the GAD Timpala Award, to highlight the activities and accomplishments of the Commission and the HEIs. Through this system, the Commission is adamant for a transformative and Industry 4.0 ready gender and development system that caters to the needs of our stakeholders. Everyone's rights should be institutionalized. Men, women, the LGBTQIA+ community. It is our responsibility to provide an equitable educational system for everyone and every component of the society, our home, educational institutions, communities, and the government. As your Oversight Commissioner for Gender and Development, my vision is for this educational system to be implanted with empowered individuals without boundaries and whose dreams are meant to be fulfilled. And for this to be realized, we must work together for a system of equal opportunities free from discrimination, irrespective of gender, race, and religion. Thank you at mabuhay po ang Region 10.
Maraming salamat po, Commissioner Dalilag, for that very insightful speech po. Before the Commissioner leaves, as he has a very busy afternoon ahead, we'll take a quick photo opportunity with Commissioner Dalilag. So if everyone who are comfortable to have their cameras on, you may turn it on now for the photo opportunity. And I'd like, of course, to request the help of the tech team, Sir JP and Ma'am Kat, in taking the photo. I believe we have several frames here. There's quite a lot of people joining us in the Zoom room. Sir JP, we're waiting for your cue po.
Okay, smile. 1, 2, 3. Okay, for next batch, the station. One, two. We have 1, 2, 3, smile. Okay, next thing. 1, 2, 3, smile. Okay, another. Another pain. 1, smile. Okay. Okay. Some more. Okay, we're good. Thank you.
Thank you, Sir JP. Again, thank you so much, Commissioner. At this point, thank you po. At this point, we will take a pause for a quick mindfulness activity po, and as well as a time to massage our cheeks. That was quite a lengthy time to smile. I'm inviting everyone to get off whatever you're doing on this very busy Monday afternoon to participate in this 5-minute activity. So just take a break, get off your phone, or set aside your paperwork for a short while, and let's fully participate on this mindfulness activity. So tech team, we could play this now.
5-minute mindful breathing. Sit or lie down. Make yourself comfortable. Take a few moments to be still in your body. Allow yourself to become aware of where your mind is at just now. Take a moment to notice your thoughts. Gently close your eyes or softly gaze ahead, finding a point of focus that is not distracting. Gently bring your awareness to your breath. Start by taking 2 full breaths. Now, allow the breath to settle and find its natural rhythm. Notice where you feel the breath most clearly. This may be at your nostrils, upper lip, neck, throat, chest, belly, or somewhere else. When your mind pulls you away or distracts you during this practice, you can come back to this part of your breath as an anchor or point of focus. Breathe in naturally without controlling it. Allow your body to breathe for you. As you breathe in, be aware of breathing in. As you breathe out, be aware of breathing out. Keep your awareness on your breath as you breathe in and breathe out. In this practice, there is no need to visualize your breath, count, or slow down your breath. Just be open and aware of breathing in and breathing out. Without judging your breath or changing your breath, just watch it go in and out, like the ebb and flow of a gentle wave at the shore. In and out. If your breathing changes, that's fine. It does this naturally. Don't push it in any way. Just observe. There is nowhere else you need to be right now. Nothing you need to do. Just be here now, simply noticing your breath, living in this moment, one breath at a time. When your attention drifts away from your breath, simply take note of where your mind went and then gently bring your attention back to your breath. Ride the gentle wave of each breath, moment by moment, breathing in and breathing out. Continue being aware of breathing, noticing the point of focus of your breath without changing your breath in any way. Watch it come in and watch it go out. This breath. This breath. This breath. As you reach the end of this practice, congratulate yourself for taking this time to be present with your breath.
Thank you so much for your active participation in that mindfulness activity. So again, there are two parts on this training. The first part, which is today, is on Anti-Sexual Harassment and Safe Spaces Acts. And the second part is a training on appreciation of CODI, the composition, the roles, the responsibilities of CODI members, as well as important skills of investigators. And that is scheduled this coming June 14, 2021. So this entire program is organized by CHED Region 10 through its HR office and GAD office, and is sponsored by the Gender and Development Resource Center of MSU-IIT. So for the information on the second part of this program, that will be available in the Gender and Development Resource Center of MSU-IIT Facebook page. So you might want to check that out if you'd like to participate in the second part or the second leg of this training, which is next week, the next Monday after this. So today's conversation will center around Anti-Sexual Harassment Act and Safe Spaces Act. So just reminding everyone of the rules again, please mute yourself. You may make use of the reaction buttons to make up for the lack of visual feedback to those with their cameras off. And if you have any questions related to the discussion of our speaker, please make use of the chat function and type in your questions at any point, and we will save it for later's open forum. So for those who are joining us on Facebook, please type in your questions in the comments section of the live stream. We have harvesters who will be sending in your questions in the Zoom room. So a reminder to please start your question by stating your name as well as your institutional affiliation. And after today's training, please don't forget to complete the post-test as well as the evaluation form. So the link to those forms will be shared later in the chat room, and that will be the basis for the release of the e-certificates. At this juncture, I'll do the honors of introducing our esteemed speaker for this afternoon. Our speaker is a lawyer and is the owner of Peralta Law Offices. He is an assistant professor in the Department of Human and Family Development Studies, College of Human Ecology, University of the Philippines, Los Baños. He is the director of the UPLB Gender Center. He has a degree in Bachelor of Science in Biology from the University of the Philippines, Los Baños, a Bachelor of Laws from San Beda College, School of Law, and is presently pursuing a PhD degree in Development Studies at the University of the Philippines, Los Baños. Our speaker is presently a member of the Philippine Commission on Women, National Gender and Development Resource Pool. He's a seasoned paralegal trainer on gender-based violence, sexual harassment, and related laws on abuses and discrimination. He's also an experienced researcher in gender and development studies, sexual harassment, women empowerment and gender equality, and an adept legal consultant. He's also an active member of the Academe. Everyone, please help me welcome our speaker for this afternoon, Attorney Eric Paul D. Peralta.
Good afternoon, everyone. Thank you, Miss Queenie, for that very warm introduction. Kamusta po kayong lahat? I would like to greet CHEDRA Director Dr. Raul Alvarez Jr., Dr. Socarno Tanggol, Commissioner Aldrin Darilag, CHED officials present in today's webinar, of course, Ma'am Natalie Igot, and Zoom participants who are present today representing various HEIs, SUCs, LUCs, and partner agencies, I believe, in Mindanao. Magandang hapon po. Again, I would like to congratulate CHED Raw 10 and MSU-IIT for having this kind of a webinar series, no? And also express my gratitude for inviting me to be the speaker for today's afternoon and for next week's. I would have wanted to be there with you physically, but because of the restrictions, we are compelled to conduct this kind of training online. But I hope you would just imagine that even though I am miles away, I can deliver this to all of you. Okay. So in this webinar, if you have questions, you just have to type it in our chat box at the Zoom. For those who are tuning in Facebook, you can just type your questions in the comment box. Apologies, as I have provided the Q&A portion at the end of my webinar, which will be later. But you can throw away your questions and I will immediately answer it given the time. And we have mini workshops in the course of this webinar. So I hope that the 239 participants will be answering through the chat box your answers to our workshop. Also, for our Facebook participants, you can type your answers in the comment box. With that, I hope and pray that we will have a fruitful, learning, and empowering afternoon today. Allow me please to share my PowerPoint deck. All right. So as mentioned by our esteemed moderator, our topic for today will be on appreciation on Committee on Decorum and Investigation, the Anti-Sexual Harassment Act, and Safe Spaces Act. This is just for day one. And this webinar, these are the expectations after the webinar that the participant is expected to learn, review, and recapitulate the relevant and existing laws on sexual harassment, understand the salient concepts and principles in these laws and their effects, know how these laws with these concepts and principles can be utilized as CODI members. I believe that some, if not most of you, are or belong to the CODI, and apply the knowledge and learnings today to your respective institutions. Discussion points will be four. We will be tackling four laws this afternoon. First will be the Law on Anti-Sexual Harassment Act, or RA 777. We'll be discussing CMO number 1 series of 2015. I'm very glad that Commissioner Darilag already provided some sort of an introduction on what this policy is all about. We will be discussing the 2017 RACs. For information, the RACs that we have is a specific portion for sexual harassment. And of course, the recent law that we have on sexual harassment, which also specifies the composition and functions of CODI, which is the RA 11313 and the Safe Spaces Act. Alongside the discussion of RA 11313 is my discussion on its implementing rules and regulations. Let's begin with the first law. The first law that I will be discussing is the Anti-Sexual Harassment Act of 1995, all right? Or what we know as the RA 777. Now, this law was enacted on February 8, 1995. So relatively, this is somehow an old law that has still been, still exists and binds us today. It is composed of 10 sections, and actually the title of the law is this one, an act declaring sexual harassment unlawful in employment, education, or training environment, and for other purposes. Now, the title itself will depict that sexual harassment is unlawful, meaning that it violates a law, and therefore the violator or perpetrator can be punished. Now, this is a crime, criminal law, a penal act, so the punishment can be fine and or imprisonment. All right. Now, going inside the law, it is clear that the policy of the state on sexual harassment is that sexual harassment is unlawful. Previous to this law, there are no laws really focusing or specifying sexual harassment as an unlawful act. Now, I can say that this law is the first law that declared the act of sexual harassment as an unlawful, meaning that it violates a law, and therefore, upon violation, there can be several liabilities that can arise thereof. Also, the good thing about this law is that it categorized 3 places upon which sexual harassment can happen. First is in a workplace environment, second, in a training environment, and third, in an education environment. And apart from stating that sexual harassment is unlawful, it also emphasizes the fact that the state will not tolerate these kinds of acts. All right? So this is the policy of the state on sexual harassment by stating that the act is unlawful and that the state will not tolerate these kinds of acts. Why? Because it violates the dignity and human rights of a person. All right? So the act of not tolerating this, or the reality of not tolerating this act is actually premised on human rights and the dignity of every Filipino. All right? Okay. Now, the definition of this work education or training sexual harassment is quite long or quite general, but it focuses, so we would like to invite your attention to the focus that in this kind of definition, it highlights the presence of authority, influence, or moral ascendancy. Okay? So in other words, the perpetrator must have authority, influence, or moral ascendancy over the victim for the sexual harassment act to fall within RA 777. Take note, this law has been there, was enacted way back in 1995. And the lawmakers that time seemed to connect sexual harassment into the abuse of authority that can be performed by those in possession or by those who have higher influence or those who have moral ascendancy over the victims. And in this definition, you will see that one kind of sexual harassment has only been defined. The act of demanding, requesting, or requiring for any sexual favor. So that's only one, but there are a lot of kinds of sexual harassment which has been existing way back 1995. But this definition only focused on this kind of act of demanding, requesting, or requiring any sexual favor. Now, the good point about this definition is that with that kind of act of demanding, requiring, or requesting for sexual favor, it emphasizes the fact that the object need not accept or reject the object of the demand, request, or requirement. At the last part of this definition, I invite you to that last part. It says that demands, requests, or requires any sexual favor from the other, regardless whether the demand, request, or requirement is accepted by the object of the act. Now, why is that important? It is important because it directly states that the recipient of the demand, request, or requirement need not accept or need not reject for sexual harassment under 777 to happen. In other words, the mere demand, the mere request, or the mere requirement for a sexual favor is already the criminal act, which allows the victim to file a case under RA 777. All right, I hope you understand that, no? That this is only one kind of sexual harassment that is present here. But the good thing is that it directly says that the recipient of the demand, request, or requirement need not respond, because the mere demand, request, or requirement is already a punishable act under this specific law. Okay, now apart from defining or capturing the definition of a work-related, education, or training-led sexual harassment, no, the law proceeded in this manner by defining each of those aspects. Now, first, about work-related sexual harassment. Here, you will see that there are three kinds, no, of definition. All right. So, accordingly, sexual harassment, work-related, can be committed by the following. No? Take note. The first item pertains to submission to or rejection. Submission, you submit, you allow, or rejection, you reject. And the act of submission or rejection was used as a basis for any employment decision. All right? So it means that the basis for the employment decision is not by merits alone, but because you submitted to the act or because you rejected the act or series of acts. Now, question, what are matters covered by employment decision? It includes hiring, promotion, raises in salary, job security, and any other personal action. So in other words, apart from defining the act of work-related, training, or education-led sexual harassment, and by providing a single definition there, or single act there of the demand, request, or requirement for sexual favor, it appears to be that the act of sexual harassment can also be by way of work-related sexual harassment by merely basing an employment decision on the submission to or rejection of the act of sexual harassment. Okay? Second, take note that the second act pertains to those acts which have the purpose or the intent or the effect of interfering with the work performance of the victim or creates an intimidating, hostile, or offensive work environment. I would like to emphasize on the purpose or the effect, meaning to say that the act itself can be considered, or its purpose, or even the effect. And in fact, even the act itself is not there as long as the environment that is created is intimidating, hostile, or offensive, then there can be work-related sexual harassment. Third, okay, if the act or acts might reasonably be expected, all right, to cause discrimination, security, discomfort, offense, or humiliation to a complainant. All right, so here, even though the act itself is not considered as an act of sexual harassment, but upon deducing the act, it can be reasonably expected to cause discrimination, insecurity, discomfort, etc., then there can be work-related sexual harassment. All right? The framing of RA 7777 is like that. It did not list the acts of sexual harassment, but by way of definition, it provided for how these acts can be committed. Apart from the general definition a while ago, it then specified the kinds of sexual harassment, number one, for work-related environment, and second, in a training or education-related environment, which you will see later. All right, now we go to education-related sexual harassment. The definitions are quite similar. It's different in this number one item, whereby, again, it talks about submission to rejection, but here, it's not anymore on the employment decision, but on the basis of providing for a grade. Okay? Second, granting of honors. Third, payment or type of stipend or allowance. Fourth, giving of any benefit, privilege, and consideration. Of course, these acts are not absolute because it can accommodate further, as long as the basis will be the submission to or rejection of the act. Okay, these acts are not exclusive because it covers including but not limited to. Okay, so it can be other similar acts or analogous acts which has the same intent or effect. Same again, second or third. The second talks about the purpose or effect that causes interference in the performance or the creating intimidating, hostile, offensive academic environment on the victim. And third talks about not about the direct acts of sexual harassment, but even though the acts are not directly Sexual Harassment Act, but can be reasonably be expected to cause discrimination, insecurity, discomfort, offense, or humiliation. There can be work or education-related sexual harassment under RA 7877. Now, there are Supreme Court cases on RA 777 like this one, Narvasa versus Sanchez. So you will see here that there are text messages. In fact, there are questions on pauwi ka na ba, sexy, slept and dreamt nice things about you, have a date with me. So the Supreme Court is already aware of violations of this law. Now, there's this Domingo versus Rayala whereby there are already physical contact on the part of the victim, holding and squeezing, running the fingers, tickling the ear, right? Inappropriate conversations, giving them money. In fact, the Supreme Court says that it all resound with deafening clarity, nakakabinging kaklaruhan, that the unspoken request for sexual favor. There's also a case in Digital versus Soriano whereby in a party, one of the perpetrators grabbed his hand and poked her vagina several times. And another is that during when the victim was dancing, the perpetrator groped her breasts and buttocks. Okay, now I would like to highlight this important part of the law, that the law mandate employers or heads of offices to have a duty in connection to sexual harassment. Okay, now the duty first is that the employer or head of office should prevent or deter the commission of acts of sexual harassment. In what manner? By providing the procedures for resolution, settlement, or prosecution of acts of sexual harassment. By experience, here in UPLB, if there's a victim of sexual harassment, the number one that the victim will ask is where to file a case, what to do, where can I have support, or what documents need to be submitted. So those things are provided for, or should be provided for, as a duty by the employer or head of office as mandated by RA 7777. Now, this can be done by way of number one, promulgating appropriate rules and regulations on what? On prescribing the procedure for the investigation, okay, as well as the sanctions therefore. Commonly, without any CODI, without any procedure, what happens in other SUCs that I have done lectures with is that they file a case with the dean. For example, in employer-employee sexual harassment, they file a case with the HR. So that's what they do. That only shows that there is really indeed an absence of a procedure that is provided for by 7877 pa lang. There are other laws that also provide the same provisions. So by 7877 itself, it's very clear that the head of office or employer should prevent or deter by providing procedures on what? Resolution, settlement, and even prosecution. Because, of course, the lawmakers are very much aware that upon abuse, the victim should have somehow ways on how he or she will have redress or relief for that matter. Okay, so that's number one. If there's a procedure, then there's clarity as to what can be done based on the unlawful act, which is clearly unlawful as defined by the law. Second is by creation of a CODI. Now, as early as RA 777, the concept of CODI is already there. Okay? Now, this CODI, and most common that we know is it's a Committee on Decorum and Investigation, has the duty to what? Conduct meetings with, necessary people and to increase understanding and prevent incidents of sexual harassment. Okay? And next, the CODI shall conduct the investigation of alleged cases constituting sexual harassment. So in other words, as early as 1995, the law already initiated or acknowledged the fact that there should be an independent or a mechanism upon which cases of sexual harassment can be properly addressed. The problem with 777 is that it did not really clarify or provided for the specific functions and even representation on the part of the CODI. And this is the reasons why there are several laws that came about to reinforce this specific law. All right, so 777 is quite general in stating that the functions of the employer are just two, by providing procedures, and second, by creating a CODI. But true enough, it is supplanted or supplemented by succeeding laws henceforth. All right. Okay. Now, because there was a duty, no, 777 said that there should be a corresponding liability. Okay, now what's the liability? One liability is that a liability for damages. You talk about damages, we're talking about a civil action or money. Now, when can there be damages? No? Again, 777 is very general in form. It states that there can be liability for damages if there's no immediate action taken. Okay? So, when are the instances wherein no immediate action can be taken? If there's no procedure. All right? There's must be proper procedure so that the days upon which this can be responded to or the date of filing, the date of submission can be properly be clarified and put into a specific policy. Okay? Now, it can be solidarily liable, meaning to say that the victim can go against the employer, head of office, or training institution and claim from the uh, employer, head of office, or institution damages alone. No? All right? And in fact, this can be separately and independently instituted. Okay? Now, if this victim will seek advice from a lawyer, I think this can be a proper or a valuable option, a viable option for that matter, because this in this provision, apart from making the perpetrator liable criminally for penalty or imprisonment or fine, then there can be a civil aspect of it. If there's no immediate action that is taken, it commonly happens if there's no procedure on what to do. That sometimes cases like this will be delayed because there's no proper steps on what to do upon filing a case. All right. Okay. All right. Actually, this is one of the inefficiencies or gaps or loopholes of this law, that the penalties are quite low. Here you will see that the imprisonment is only 1 to 6 months, or a fine of not less than 10,000, not more than 20,000 pesos or both. All right. In fact, this is within the jurisdiction of the municipal trial courts or the first level courts of the Philippines. Okay. So this is the penalty. These are the penalties of the violation of RA 777. And the good thing is that the prescriptive period is 3 years, meaning to say that if the act, for example, today will be the filing of the case, June 7, 2021, you can file a case for actions that happen from June 8, 2018. Because 3 years henceforth from June 8, 2018 cannot be covered because the act prescribes. Okay, that's the meaning of prescriptive period. The act prescribes already. All right. So that's the penalty for sexual harassment under RA 777. Let me just check the chat box for questions. Okay. Mukhang wala pa po. So I am greeting everyone who just came in. Welcome po sa ating webinar. All right. So we now proceed with the mini workshop. Are the 238 participants still there? Okay, so I'm expecting 238 answers. I will enroll in your class, sir. All right. Ano pa yan? Masyado pa maaga dyan. Okay, so please assess the case provided that will be given. Okay. A supervisor forcibly kissed the neck of B, his subordinate. Question, is there a case of sexual harassment under RA 777? Type your answer and a brief explanation in our chat box. Okay, take it plainly as it is. Don't add any other facts, okay? There's a period. Don't add any other color, okay? It's just the case is just as it is, all right? A supervisor forcibly kissed the neck of B, his subordinate. So is there a case of sexual harassment under 777? Type your answer and a brief explanation in our chat box. Okay, I can see a lot. Dagdagan ng explanation. From Marideth, meron siyang explanation. Forcibly act. Okay. I get it. How about the others? Just provide a sort of a words or short. Because the important thing is the explanation, no? All right. Okay. There was no consent, correct? Forcibly act, forcibly act. Supervisor. Correct. It's a good point, no? All right. Ma'am Reyna, ano po yan? There's an authority. Because here, this is a supervisor. Di ba in 777, there must be authority, influence, or moral ascendancy. Now, the authority is present here. So the correct answer is yes. The reasonings are there. Number one, there's authority. Number two, there's force. No? Forcibly kiss the neck of B, his subordinate. Okay? Now, technique. No, in sexual harassment cases, especially when you look at with 777, no, always take note of the personalities. No, first check whether there's authority, influence, or moral ascendancy, then proceed. Okay. All right. Next. Our next question: A, a subordinate forcibly kissed the neck of B, his supervisor. Is there a case of sexual harassment under RA 777? Is there a case? But puro yes Teka. I-cut ko na kayo The answer is no. If we will base the scenario under RA 777, no, the subordinate, as it is po plain as it is, no, being a subordinate, you have no authority, you have no influence or moral ascendancy over your supervisor. As it is, don't add anything, no. So in other words, the first element of authority, influence, and moral ascendancy is not present. So there is no sexual harassment under 777. But question, can there be other crimes? Of course. Shed Memorandum Number 1, Series of 2015. It is an HEI. CMO Number 1, Series of 2015 does not, or does not consider authority, influence, and moral ascendancy. 2017 RACs do not consider authority, influence, and moral ascendancy. RA 11313 do not consider authority, influence, or moral ascendancy. It just so happened that RA 777 considers that requirement. So if the question is that, is there a case of sexual harassment under 777 given the scenario, plainly as it is, there is none, but there can be other crimes. All right? So I hope you understand that. I hope we're still on the same boat. Okay? Okay. Okay, next. A supervisor requested a quickie from a subordinate in exchange of a promotion. Ayan. A supervisor requested a quickie from a subordinate in exchange of a promotion. Is there a case under sexual harassment under RA 777? Type your answer and explanation in our chat box. Okay. Yes. Explanation, use of power, authority, the request. Very good. The request itself is sexual harassment. Very good din yung isa. Sabi, si Ma'am Chris Lagang in exchange for promotion. Again, work-related sexual harassment, di ba? It's connected to a personal action. Okay. Yes, kaayu. Abuse of power, authority, abuse of authority. Very good. No? Okay, I'm very happy that you got it. No? So here, it's very clear. There's a demand, request, or requirement for a sexual favor. Okay? Sexual favor pa, dagdagan pa in exchange of a promotion, which makes it work-related sexual harassment punishable under RA 7877. All right, thank you. Okay, how about this one? A subordinate demanded a quickie from his fellow subordinate in exchange of a promotion. Okay. All right. The answer is no. No, because there's no authority, influence, or moral ascendancy here. Although it gives a intimidating, hostile environment, the act of demanding, requesting, or requirement for sexual favor is there, but still the element under 777 of authority, influence, or moral ascendancy is not present, making it not punishable under 777, but can be punishable based on other crimes. All right? Okay. All right. Thank you po. Ito po. A subordinate demanded a promotion from his supervisor. Is there a case of sexual harassment here? None. There's no sexual overtone, there's no sexual underpinning. Okay, meron pong tawag sa Tagalog nito eh. Makapal po ang mukha. Actually, panggising ko lang po yan. Alright, next. A, an employee required a blowjob from an applicant to ensure that his application will be granted. Okay, so does it cover a personal action? Is there authority, influence, or moral ascendancy here? Okay, let me see your answers. Yes, I'm interested in the reasons. Probably. Okay, it's a sexual word. Yes. How about your reasons? All right. Okay. Wow, BJ. Okay, so is there a request requirement? Is there a request requirement or demand for a sexual favor? Yes. No. Is there authority, influence, or moral ascendancy? Yes. No. So there's a case of sexual harassment under RA 7877. How about this one? A, an employee required a blowjob from an applicant in exchange of money. Yes, sexual demand, correct? It's actually a sexual requirement, no? How about the issue that it's just in exchange of money? Will that matter? Okay, that will not matter, no? Because here, there's a demand or request for a sexual favor, no? The kapalit, no, is not actually provided for by the law, but there's another reason why this is a sexual harassment act under 777, in that it provides an offensive, no? It's an offensive, intimidating, hostile, or humiliating environment. Okay, we go to the education environment. A professor forcibly held the breast of B student. Is there a case of sexual harassment under 777? This is very easy. Can I see your reasons? Why? Authority, correct? Right? Forced, correct. Okay, I saw already the reasons. No? Force and authority are present. No? Forcibly held the breast of me, student. Thank you. To the moderator, sometimes I admit participants, no? Sorry, kasi it appears on my screen. All right, how about this one? A janitor forcibly held the breasts of B. No? A student. A janitor forcibly held the breast of B, a student. All right. Hindi ko po na ano yan yung Bisaya, ma'am, na sorry, Tagalog po. All right, no? By being an employee of the given institution, that gives a janitor an ascendancy, all right, over the constituent who is a student. Okay, so that gives him or her, no, an ascendancy on that part because he's part of the institution. Thank you po, Ma'am Geraldine. All right, so there's a case of sexual harassment under RA 7877. Manyaki sa janitor. Okay, yes. All right. Okay, I apologize. I can't read all the answers, no, but I acknowledge each and every answer that you're giving. Okay. A male professor demanded a sexual favor from B, his male student. B refused the said demand. Is there a case of sexual harassment under RA 77? Okay. Yes, bakit po? Demand. Yes, why? Hindi ko pa nakita yung isang reason. Okay, thank you po, Ma'am Bernice. Maraming salamat po. Okay. Follow-up question. What about the issue, okay, that the student refused? Will that matter at all? It will not matter. Di ba? As what's defined a while ago, regardless whether the recipient, no, accepts or rejects the act. Okay, from USTP, Ma'am Claveria, thank you. Regardless, nagigets ko na po yan. Okay, from Axel Chan, regardless. Okay. Follow-up question, number 2. What about the issue that both of them are males. Will that matter at all? Okay, thank you, Ma'am Althea. So in fact, I think the real question is, no, can, no, a male perpetrator harass, no, a male victim? Can victims of all can people of all genders be harassed? The answer is yes. Okay. So there's no classification or qualifications to gender. So whatever gender you may be a victim, you may be also a perpetrator. Okay, I think that will be the end, no? Because I have to observe time. So maraming salamat po sa mga nag-respond, no? I would like to give you a warm round of applause. Okay? Yes, still sexual favor. Thank you, thank you. Okay, hindi pa tayo tatapos ha. Mahaba pa po ito. Kaya po iniklian ko na so we can finish. Alright? Okay. Now, if you have questions on 777 alone, just type it in our chat box, no? Because I am compelled to proceed so that we can finish by 5 o'clock. All right. We now go to CHED Memorandum Number 1, Series of 2015. No? Like what Commissioner Darilaga was mentioning, no? This is one of the milestones, no? Or one of the policies that was enacted by CHED in connection to sexual harassment, no? And I have lectured this so many times, no, in various regions, no. And Ma'am Nats is actually one of the participants before, and I think this policy is really sufficient or apt, no, for higher education institutions, no. So I would like to congratulate CHED, no, for doing this or for initiating this effort, no, because it really reinforces, no, RA 777, which appeared to be lacking, no, as you can see a while ago. Okay. Now, the policy and coverage of CMO number 1 series of 2015 is this one, that it directly states that all HEIs shall ensure that policies and mechanisms are in place, okay, to prevent and punish sexual harassment. Now, it added a new flavor and added related and other related sexual offenses. Okay? So again, there's a direct mandate on HEIs to ensure that there are policies and mechanisms that are in place to prevent, not only to prevent, but also to punish not only sexual harassment, but also other related sexual offenses. And that covers those acts that are not sexual harassment, but are deemed sexual in nature and effect. Okay? Now, apart from that, CMO number 1, Series 2015 also provided that the provisions of that CMO shall govern the creation of the CODI. Okay, that the CODI should be created in all public and private HEIs. Not only that, but also the procedures to be followed in prosecution and investigation, not only of sexual harassment, but also other related sexual offenses. So this reinforces the provisions, particularly the duties of the employer as provided for in RA 777, that it emphasizes the fact that it should also be the same, no, in HEIs, may it be a public or private one. And it added a new flavor that it not only covers sexual harassment, but also other related offenses, sexual offenses for that matter. Okay. Now, the definition of sexual harassment is this one. It states that the administrative offense of sexual harassment. So again, we must compare it to 777 because that one is a criminal one, meaning to say that the penalty is fine and or imprisonment. Here, what CMO number 1 series 2015 talks about is the admin offense of sexual harassment, whereby the penalties is quite different from the criminal act of sexual harassment under 777, because here the penalty can be reprimand, warning, suspension, and dismissal or expulsion from the institution. Okay, now it covers the following. It's an act or a series of acts involving any unwelcome sexual advance. Now it is it encompasses a lot of acts, no? Because any advance can be verbally made, can be physically made, okay? Or can be made through the use of technology for that matter. In fact, this CMO already captures that reality that this can happen by way of internet, by way of social media, no? By way of the devices that are accessible nowadays, no? So apart from that, it reiterated about the request or demand for sexual favor. Okay, you'll see here, no? This one was in place in RA 777 was reiterated by CMO number 1 series of 2015. And next, no, it also captures other verbal or physical behavior of a sexual nature. So it appeared to be that there are three categories of sexual harassment here. First, unwelcome sexual advance. Second, request or demand for a sexual favor. And third, other verbal or physical behavior of a sexual nature, which I strongly believe covers, no, all acts of sexual harassment. Okay? Now, this can happen in a work, training, or education-related environment. So again, this replicates what 777 or the environments provided for in 777 wherein sexual harassment can happen in a work, training, or education-related environment. So by way of this definition, no, it captures, no, I think the acts of sexual harassment that must be punished within the context of HEIs. Okay? Now, it directly provided a definition on what, Ma'am Hazel, I will answer that after CMO number 1 series of 2015. No? Okay, moderator, just please take note of this one. HGH, MNDS, I will call you after this one. No? The PowerPoint on CMO is quite few. Okay? So, tayo lang po. So, education, training, and sexual harassment is somehow expounded the definition as provided for in 777, whereby it can be committed against one who is under the actual or constructive care, custody, or supervision of the offender. That's the first one. Second, against one whose education, training, apprenticeship, internship, tutorship is directly or constructively entrusted to or is provided by the offender. Okay? So that's the first one. Second is when the victim submits or rejects, and that those acts can be the basis for giving a grade, granting of honors, payment of stipend, similar to what is provided for in RA 777. No? Yung pagpayag mo, tsaka yung pag hindi mo, yung nagiging basehan sa grade mo, sa honors mo, sa allowance mo, at sa kahit anong pribilehiyo na ibinibigay sa'yo. Right? Third is actually copied also in 777 about the purpose or effect, no, of interfering with the academic performance, no, of the victim. And lastly is that, no, not the direct act, but even if the acts are not directly sexual harassment, but if it is expected to cause discrimination, insecurity, discomfort, offense, or humiliation, and there can be, you know, education or training related sexual harassment. Now, I mentioned a while ago that, no, apart from covering acts of sexual harassment, this CMO also covers other forms of sexual offenses. Now, what is this? Okay, as provided for in the CMO, this includes verbal, physical, and cyber harassment of a sexual nature. So like what I was mentioning, no, the CMO already captured the fact, which readily happens today, about harassment that can happen in the cyber world, and is captured by way of it categorizing under other forms of sexual offenses. Now, it also covers use of lewd language, even voyeurism, texting, and bullying, okay, with sexual content. Okay, so although it's not captured under sexual harassment, but, no, these are acts of sexual offenses that can be captured also, no, by CMO number 1 series 2015 that can fall also within the jurisdiction of the CODI. All right? So apart from that, this CMO also mentioned that the victims or the perpetrators of sexual harassment can be same, no, or opposite sex. Okay? Then it follows through that there can be no authority influence or moral ascendancy, but sexual offenses or sexual harassment can also happen within peer relationships. So mean to say that there are chances or opportunities whereby there's no authority influence or moral ascendancy, but there can be sexual harassment under CMO number 1 series of 2015. So it goes away or veers away from RA 777 that law requires authority influence or moral ascendancy. This time, wala na. And in fact, it also captures the fact that students can harass employees or that students can harass faculty members by virtue of this CMO. Okay? Because erstwhile, no, by basing the with the basis of 777, students would deem to harass faculty members or employees because the requirement of authority influence and moral ascendancy is there. Now it is removed, and CMO veers away from that element by accommodating these kinds of sexual harassment acts. Now there's a remedy. There's a clear remedy for sexual harassment acts that are happening, no, with peer-to-peer relationships, or if the students are harassing employees or faculty members. All right. So as compared to 7877, CMO number 1, City of 2015 provided for the places where sexual harassment can happen. So it can be within the premises. In fact, it can be whatever, no, as long as the parties are found because of an education or training responsibilities or relations. It can be in a social function. It can be while on official business. It can be in conferences. No? And I think the important part, no, for me, which applies nowadays, is this one. If the harassment can happen through telephone, cell phone, fax, email, or social media. No? Alam naman natin, no, all of us have social media accounts, and most of our students also have a number of social media accounts for that matter, and they can be harassed, no, with the use of this technology, which is not captured really by RA 777. Okay. All right. Apart from that, no, the good thing about this CMO is that it provided for mechanisms to provide assistance. So apart from really putting functions into CODI, no, this CMO acknowledge the fact there should not only be investigation. All right? These are traumatic incidents whereby there should be counseling, guidance, spiritual counseling. No, if not possible, if the HEI is not capable to do so, they can refer it to agencies offering professional help. Okay? Now, the concept of a God focal committee is already there. Coordination can happen and available legal support. Okay? So take note of this one. No? Not only is the CMO providing for a remedy by way of a CODI, but apart from that, no, the HEIs may adopt mechanisms. No? It's not a directive, no, but they have the option to adopt mechanisms to provide assistance. I think for me, this acknowledges the fact that sexual harassment incidents or acts are traumatic incidents, no, or acts of a heinous nature whereby there should be proper support, not only legally, no, but can be through counseling, no, or through other means of support. And in fact here, linkages can be accommodated, no, and support from various God committees present in the agency. Now, apart from that, not only the victims should be, no, provided assistance for, okay, the offender may, no, or the HEIs may provide professional counseling also to the alleged offender. Take note, they are just alleged offenders. No, there's no ruling from the disciplining authority yet. No, that's why they call an alleged offender. Diba? We have this innocence, no, beyond before siya makasuhan, kailangan inosente muna pagtingin natin sa mga yan. That's why alleged offender pa lang dito. So in other words, both parties, may you be a perpetrator or a victim, can be provided assistance on the option of the HEI because it's a may. No? All right, but it can be done, then it's proper because I believe, no, that this incident should be properly addressed, no, not only legally, but in various means or various ways. Ma'am Maridet, wait lang po ha. I will just finish this one. All right. Duty to report and document. it was mentioned that any or all persons who have knowledge, I say knowledge, who knows, no, of any acts akin to sexual harassment or other sexual offenses, they shall report the same to the head of the institution. So it appears to be that the reporting, no, is a duty on the part of the persons who know it. Okay. Now, similarly, with the provision of the duties to the head of office, no, the duties of the head of institutions upon complaint or reported incidents is this. No? The guidance counseling offices, no, shall have appropriate facilities and registered guidance counselors, so that if harassment cases can happen, they are fit, no, or capable of addressing or handling these kinds of cases. The head of institution shall create again a CODI, which was actually discussed, no, in the previous provisions on CMO, that the CODI should be created so that, no, the provisions of the particular CMO should be properly or efficiently implemented. Okay? Apart from that, the head of institution shall have or shall ensure a program to capacitate, no, the officials, no, the human resource department for efficient and professional handling of sexual harassment cases. No? And this program should be institutionalized. In fact, no, CMO is serious in directing these provisions because, no, there's a provision that if the head of the institution fails to act on the complaint within 10 days of receipt, no, there can be a charge of neglect of duty which is punishable by the 2017 RACS. Okay? Functions of the CODI by way of CMO number 1 series of 2015, receive complaints. This is very important, no, that complaints are received by the CODI. Okay? Now, the complaints can be sexual harassment or other related sexual offenses. No? Investigate complaints. Okay, of course. And in accordance with the prescribed procedure. So impliedly, there should be a procedure already, no? Because it is in accordance with the appropriate prescribed procedure. Okay, submit a report to the disciplining authority for decision. CODI is only recommendatory and provides for sort of an investigation report on what happens. Fourth, lead in the conduct of discussions about sexual harassment, no, and offenses within the institution so that the community will have an increased understanding. So this flows from the previous duty of CODI in 777, whereby stated that there should be meetings, no, and should increase awareness or understanding on the part of the community to prevent incidents of sexual harassment. And lastly, to conduct other activities that would engender a safe environment for women in school campuses, as well as in the training-related programs in HEIs. Okay, the position of CODI is provided for in CMO that there should be at least one. Can there be two? Of course, no, at least one, each from admin, employee, or non-teaching, trainers, coaches, training personnel, and students or training as the case may be, which should be selected by the school's disciplining authority. The term of office, no, can be made or provided for by the HEI, but it should not be more than 2 years. No? Okay. All right. We will not be having this break so that I will be able to finish, but I will use this one to answer the questions. So if you have other questions, just chat it right now, but I think I parked some of them. Okay, from Miss Hazel Marie Reyes Boloron. Question: What will the victim do if the CODI failed to submit the report at a defined period of time? Well, Ma'am Hazel, as provided for kanina, you have several remedies, no, for the delay, no, or unreasonable delay on the part of the CODI to fail to submit. Now, before they become CODIs, they have respective appointments for that matter, and that appointment will have several functions. So basically, you can proceed, no, to pursuing your case before the civil service kasi may appointment niyan, tsaka may function, no? So there's a government function, there's an appointment. In some cases, CODI members are provided with honorarium. So you can proceed with the civil service commission, the regional office that covers the school. Perhaps first, before that, you can proceed with disciplining authority, making it or putting it on record that there's a specific delay that is happening and what can be the liabilities that should be imposed upon the CODI members, no, who delayed the case. Now, if you're not satisfied, you can elevate it to the Civil Service Commission Regional Office, and after that, Civil Service Commission Main Office. If that's your question, if the remedy, no, but if what will the victim do? That can be the option of the victim. That can be the remedy that should be done by the victim in that matter. Okay, if the colleague took time to submit the report, no, well, if it is beyond the provided the prescribed number of days as provided for in the civil service or in the CHED memo, and also it violates the one provided for in the procedure of that institution, then still the remedies that I advised can be properly performed. In sexual harassment, what would be the basis? Is it the law or the CMO? Okay. Take note po, Ma'am Marideth, that for sexual harassment outside of the institution, the basis should be 777 or RA 11313, which I will discuss later. Okay? The CMO tackles about administrative sexual harassment. Can these two angles be pursued simultaneously? The answer is yes. Okay? It can be done simultaneously. Right? Because they have various quantums of evidence. When we talk about the criminal aspect of sexual harassment, the degree of evidence required is guilt beyond reasonable doubt. For admin offenses, it's only substantial evidence. So in other words, the evidence requirement is quite lowered as what's compared for the criminal case. Sometimes naman, what my clients are doing is that to exhaust first the admin remedies before filing for a criminal case. And utilize the decision in the admin as a corroboration or an enforcement to the criminal case of sexual harassment. They usually do that, especially nung wala pa pong RA 11313 kasi ang baba lang po ng penalty. So I will advise na doon ka na lang sa admin at least you have some sort of a immediate justice, and kasi pag sa 777 you see that the penalty is just 1 month to 6 months imprisonment. And or fine of 10,000, 20,000 pesos. So the only thing that you are holding in is that the inconvenience of being an accused in a criminal case. Malaking po talaga yun. Pero yung bang hustisya na gusto mo, yun po yung kadalasang na-advise ko, unahin mo na yung admin. Alright. Okay, from AMC College, President Roger Lopez, is there sexual harassment if both Mrs. A and Mrs. B are married and works in the same school? Mr. A makes sexual advances with Mrs. B, his wife, against her will. Okay, so it will depend kung 777 po ang ating pag-usapan. Alright, in both laws, 777 CMO number 2015, number 1/2015, there's no qualification as to the relationship. So whether you be married or not, whether you have a relationship with that person or not, if at that single point, the victim will feel that he or she will be harassed on the act itself, then he or she can file a case for sexual harassment. Okay? The defense or the fact that you are married, I think, will be the defense of Mr. A, stating that I did that because we're married. We keep on doing that, But again, the law does not qualify. The law does not provide that an exception to the rule will be that if the couple are married or if the parties are married. So I can say that there is still sexual harassment if the sexual advances is against the will of the victim. Right? Because these laws are focusing on the perspective of the victim. And the law does not qualify whether they are married or they should be married or not, or they're in a relationship or not. Okay, from San Isidro College, Dave more. What about using jokes, sexual jokes, playing with double meaning can be? Okay, this can be grounds for sexual harassment if the recipient of the jokes will be harassed, or that if it creates a hostile environment, or that the jokes appear to intimidate the recipient. So those can be grounds for sexual harassment, even though No? It is a joke if the recipient does not take it as a joke, but for the recipient, it is offensive, it is humiliating, it is intimidating, and he or she felt that he or she was harassed based on that sexual jokes or playing double meaning words. So by all means, that victim can file a case of sexual harassment on whatever ground, on whatever laws that he or she will be using. Welcome po, Ma'am Hazel. Ma'am Nelpa from Misamis University. There is a limitation as provided for in RA 777 that the prescriptive period is just 3 years. No? So after 3 years from the date of commission of the act, the filing or the cause of action already prescribes. No? So yun po yung prescriptive period. No? The cause of action after 3 years, the cause of action already prescribed. So you have 3 years from the date of the occurrence of the incident to file a case. What if a CODI member, from Buksu, Ms. Marichu, Montesilio, what if a CODI member is a perpetrator and has due influence on other CODI members? Where will the victim? Mas provided, hindi ko pa po napapag-usapan yung yung RACS, no? Pero sa 2017 RACS, if CODI member is a perpetrator in any manner involved in a case, then if it's governed with government offices or as a SUC, no, or LUC, the remedy is for the victim to file a case before the Civil Service Commission, as provided for in the RACS. This is the time whereby the CSC will have jurisdiction if the CODI member is involved. Namasagot ko na po ito, Sir Dave. Okay, from Miss Hazel again. Is there a penalty if the head of agency failed to respond to complaint within 10 days? Okay. All right. In 777, you will see there that the penalty can be by way of damages or civil action if there's no immediate action. Okay? So you just have to argue whether the lapse of 10 days is not an immediate action. You just have to show proof that it's not immediate, and etc. etc. So ganun yan. When I talk about the CMO, no, number 1 series of 2015, the penalty of neglect of duty pertains to the absence of the CODI. All right? So, but no, if there's delay like this, especially if the 10-day period is violative again of the prescribed period as provided for in the internal rules of the institution, as what's provided for in the CMO, no? Okay, or that's provided for in the RACS, then there can be also a liability for neglect of duty punishable under 2017 RACS. So, mamili na lang po kayo kung gross or simple neglect of duty for that matter. Okay? So, any more before we proceed? Welcome po sa mga nag-thank you. I think I can answer one more. Sige po, before we proceed with the discussion on the RACS and RA 11313. Okay, meron pa. Oh, welcome po. Question po. One more before we proceed. Hindi na tayo nag-break. Diretso na kagad. Are the 237 participants still present? Parang nabawasan na ito ah. Siguro sabi na ang boring nung speaker, leave na ako. Okay, thank you, Ma'am Hazel. Okay. So questions, clarifications, reflections, thoughts, so that we can properly end the two laws that we have discussed. Okay, yeah, meron. From Moist Balingasag. What if the act is committed prior to the creation of the CODI? Okay, if the act is committed prior to the creation of the CODI, if the act of sexual harassment act is committed prior to the commission of the CODI, then you can go outside of the institution if there's no CODI yet. You can go to the laws of RA 777, 11313. Wala pang CODI eh. Alright, so doon ka muna pupunta dun sa mga laws nasa labas or a criminal act. So you can proceed to the office of the prosecutor and then directly file it there and wait for the action for it to be elevated to the courts. Okay? Kasi walang CODI eh. So your remedy will be to file a case, a criminal case against the perpetrator. And I don't know if you will also accommodate that you also have a cause of action against the head of the agency, because it's provided for not only in 11313 later on, but also in the CHED memo, no, that if there's no CODI, then there can be a possible admin case, no, of neglect of duty against the head of the institution. Present po from Buksu. Okay. From USTP, Maria Teresa Fajardo, what's the trend of sexual harassment in the Philippines? Increasing po ba? All right, no. As of this day, no, the data actually is not conclusive on sexual harassment because of the lack of the physical classroom setup, no, especially in HEIs, no, and also in the government offices, no. But what I can answer is regarding violence against women during this time of COVID, which increased, no, because of the lack of a lot of factors, the lack of mobility, quarantine restrictions, no, etc. But I cannot equate that to sexual harassment acts. So the trend today is not really that conclusive because of the absence of the physical meetings, no, the work from home setup of government offices, no, the study at home setup or the flexible learning setup by the students and teachers. So it's not really that conclusive right now. What's conclusive right now is the data on violence against women and children during the time of COVID, which increased, no, because of a plethora of factors. Okay, from Medina Foundation, should the head of the CODI would be a woman or possibly any gender? Okay, thank you for that question, Mr. Aljun. Actually, as provided for in RA 11313, the woman should be the head of the CODI. All right? So from 2019 henceforth, it's already provided for by the law that the head of a CODI should be a woman and that at least 50% of its membership should be women. All right? So yun po. Women head, okay? At least 50% should be women. And it's only the first time, okay, by law that the composition was specified in that manner. Okay? Because before, you talk about the RACs, you talk about the CHED memo, talagang representation from the sectors. Dito nga sa 7877, walang ganun eh. Okay? But now, with the advent of 11313, the specifics of the composition are already provided for. As about any gender, I will invite you later on to the provision on education or gender-based sexual harassment in education environment in 11313 later, states that there should be adequate representation, no, of members belonging to various SOGI. Okay? So it may not be that there's no mandate as to the head belonging to various SOGI, but in education environment, in gender-based sexual harassment, no, the representative should have equal representation as to varying SOGI. From Moist, can he or she still file even if the act was committed a year prior? Can he or she, so even if the act was committed, if the CODI already existed and perpetrated? Okay, good question. The answer is yes. Okay, the case can be filed. All right, but be sure, no, that filing is just one matter. Okay, there should be proper evidence that you file a case. Because of the length of time, just make sure that the evidence is still preserved. Okay, so the common evidence for sexual harassment is what, no? Torn underwear, mga ganyan, semen on the pants, no? Those are my experiences dyan eh, no? Or tattered clothing. So you should find ways on how to be able to still preserve those kinds of evidence even though a year already lapsed, no? Apart from that, yung mga kumare, ang evidence ay witness, testimonies, no? So just make sure that the testimony of your witness will still be the same a year after. Alam mo naman, nagbabago-bago ang isip eh, no? Tumagal kasi ng panahon. Okay? So apart from filing, these things should also be considered so that the perpetrator can be properly liable. Of course, we talk about CODI, we talk about other tribunals or even courts, it's always evidentiary. So there should be proper appreciation on the evidence. And this, I think, will have an effect on the 1-year delay. But for filing, in your question, that can be done. Okay, meron pong private message. Hindi ko na po magaling kanino. Sabi niya, what about if the student is the one harassing the teacher? The case is handled by CODI or prefect of discipline or students. All right. In the new laws that we have today, may it be 11313 or may it be the CHED memo, no, the act of student harassing a teacher is already covered. Okay? So you can refer on these laws to guide you on what to do when it comes to students who are the perpetrators and the teacher as the victim. But that can the teacher can seek redress or relief on laws on RA 11313 in 2017 RACS or in CHED Memorandum Number 1 Series of 2015. Okay? Tandaan po ninyo, yung pong authority, influence, or moral tendency, doon lang po yung nag-exist sa RA 7877. Okay. From Mofel, John Cañete. Is the CODLI only established to cater SH issues or it caters other institutions? Okay. The answer is this, no? It caters SH issues for for HEI CODIs, no? It caters to SH issues also yung other related sexual offenses which I mentioned a while ago. Remember? Yung cyber harassment, verbal harassment kanina, lewd messages or behaviors like that. Okay, this is what's provided for in the CODI for HEIs under CMO number 1 series of 2015. So it caters SH issues and other related sexual offenses pursuant to CHED Memorandum number 1 series of 2015. Okay. All right. So I think we can now proceed with the next part of this discussion. I hope the 234 participants are still there. Okay, we now go to the 27th rule on admin cases in the civil service, particularly on sexual harassment. Okay, meron pong specific provision on sexual harassment dito po sa RACS. Okay? Now, of course, as we all know, RACS governs admin cases, specifically admin sexual harassment cases. It actually provides the offenses and the corresponding penalties. And apart from that, it provides for the remedial procedures for both complainant and respondent. Bases of which include RA 7877 or the Anti-Sexual Harassment Act that we have discussed a while ago. Now, sexual harassment under the RACS is defined as follows. No? It can be an act or a series of acts involving any unwelcome sexual advance, request or demand for a sexual favor, or other verbal or physical behavior of sexual nature. If you will notice, this is also the exact definition of sexual harassment under CMO number 1, series of 2015. Okay? So again, like what I was mentioning a while ago, I think it captures all possible acts, no, involved in a sexual harassment incident. Okay? Because the word advance, no, for me, encompasses, no, all other possible acts of sexual harassment. Committed by a government employee, syempre, we're talking about admin cases here, no? In a work-related, training, or education-related environment. There was this specification that the elements of authority, influence, or moral ascendancy are not required at all. Because here, it can cover peer-to-peer sexual harassment, subordinate to supervisor, okay, student to teacher sexual harassment. So wala na po yung authority, influence, or moral ascendancy na binabanggit ng RA 777. Okay, persons covered, of course, all government employees, no? All right, career or non-career service, any level of position, even appointees can be covered, GOCCs can be covered, and of course, government teaching institutions like SUCs, LUCs, and public HEIs. Where can it be committed? Workplace, office, anywhere, as long as they're found because of their work or training responsibilities or relations. It can be in social functions. No? It can be committed while the parties are on official business outside the office. It can be in official conferences. It can be by phone, fax, or electronic means. Now, talk about electronic means, of course, it covers those acts committed by way of ICTs, no, or yung ating information communication technology, by the use of devices. So wala na po, sakop na po talaga halos lahat. The good thing about the CMO and also the RACs is that it accommodates the possibility that sexual harassment, no, may happen even outside of the school premises for that matter. Okay? Okay, now this is one of the good things about the RACs, no? That it does not only punish, no, the one who committed the act of sexual harassment, but it also punished yung mga kakonsyaba. Okay? It punishes those who induce or directed another to commit sexual harassment, those who cooperated in the commission, without which the sexual harassment would not have been accomplished. No, in legalese, ito po yung mga accomplice, no, yung mga kakonsyaba ho. Or in the cooperation, all right, was through previous or simultaneous acts. So ito accomplice din po ito. Okay? So the good thing is that it acknowledges the fact that at times, no, it's not only the one who perpetrated the act, no, should be liable. There are also instances whereby prior to the act or even after or simultaneous to the act, there are some persons surrounding the incident which should be punished. Okay? So it accommodates, or the RACs accommodates that kind of reality. Alright? So again, no, in RACs, it's not only the one who participated, no, or who performed the act itself that should be punished. It can also accommodate the fact that those konsyaba or accomplices can still be made liable by way, no, of an admin liability pursuant to 2017 RACs. Okay. Now, the RACs categorized acts of sexual harassment into three: grave offense, less grave offense, and light offenses. All right. For grave offenses, no, these are the following acts: unwanted touching of private parts. Now, the private parts are named. Okay, genitalia, buttocks, and breast. So take note that the operative word is unwanted. It should be unwanted. Okay? So it should be unwanted, and the private parts are named. Sexual assault, the second category here, or second offense here, covers a forced sexual encounter. So it can be rape or sexual assault. Now, as long as there's forced in a sexual encounter, there can be sexual assault punishable by grave offense under the 2017 RACs. Malicious touching. Okay, now this one encompasses other acts or other kinds of touching which are deemed malicious on the part of the victim. Okay, because the victim will be the one to file the case, and that, no, it is up to him or her whether the touching was malicious or not. Okay, it encompasses a lot of kinds of touching. There's no named body part there. Okay, so if the kind of touching is malicious on the part of the victim, then there can be a cause of action by way of a grave offense under the 2017 RACs, because specifically, malicious touching, no, is a grave offense. Okay? Fourth talks about a request for sexual favor. Again, we should again look at RA 777 because that law was the one who started it. No, about a sexual favor in exchange of employment, promotion, travels, passing grade, granting of honors. No, so it's still gathered, no, some of the acts that were introduced by 777 and which was reinforced by CMO number 1 series of 2015, now placed under 2017 RACs and other analogous cases. Now, if grave offense is committed, of course, the penalty can be dismissal from service. Second category is on less grave offense. All right? Unwanted touching and brushing against victim's body. The operative word again is unwanted. Touching, what's brushing? Brushing, ito po yung in Tagalog haplos. No? Hinahaplos po against a victim's body. So there's no specific body part again whereby touching and brushing can happen for it to be made into a or fall into less grave offense. No, it encompasses lots of body parts. No, so if there's unwanted touching and brushing against a victim's body on the part of the victim, and the victim says that's unwanted, then the victim can have a cause of action under less grave offense pursuant to 27 in RACS. Second is about pinching. Yung pinching in Tagalog, ito po yung kurot. Okay? So kung pag pinching at nakakaharas yung pag-pinch on the perspective of the victim, na there can be a punishment or a penalty of a less grave offense of sexual harassment under 27 in RACS. Third, okay. Now the third one is some sort is a unique kind of sexual harassment act, because here there's no sexual underpinning or sexual overtone. What happened was there are remarks or innuendos, okay, directed towards a member of one sex or one sexual orientation, or even used to describe a person. Okay? So ito yung mga salita, okay, na nakadirekta against sa isang tao, okay, that are degrading and derogatory, okay, on their sexual orientation, or on their sex. And if that is also used to describe a person, then that can be falling under less grave offense. Verbal abuse or threats with sexual overtones, no? I have encountered one case like this. Sabi nung opisyal, tumahimik ka, pag di ka tumahimik, ra-rapin kita. Yon. No? That's a threat with sexual overtone. Re-rapin kita. Okay? That's very clear. And other analogous cases. The penalty is suspension to dismissal. I mentioned to dismissal, no, because in RACS, there is a provision on the use of mitigating or aggravating circumstances. Sometimes we apply it, but it depends on your institution whether you will apply it or not. No? For example, if an incident happened within office hours, if it happened within the office premises, those are two grave offenses. So there's a chance that if you pinched someone, and then it happened during office hours and within the office premises, that can lead you to a penalty of dismissal. Nadagdagan kasi, it's an aggravating circumstance. Yung office hours or office premises, those are aggravating circumstances which can add to the penalty. But it depends on your institution. No? Sometimes I also meet other HEIs which are not doing that kind of appreciation. No? Sabi nga sa RACS, no, there's a circumstance there about yung length of service. In one HEI that I know, ang interpretation nila is that the length of service should mitigate. Kasi the way it was worded in 27 in RACS is that mitigating / aggravating circumstance. So I believe that there should be discretion there on the part of the hearing committee or the CODI. Now, dito sa length of service, in one HEI that I know, sabi nila, mitigating yan. Kasi attorney, matagal na siya sa serbisyo, so dapat ay pagbigyan na natin ng penalty. Sa isang HEI naman, ay isang ahensya ng gobyerno, hindi HEI, sabi niya, tagal-tagal na niya sa serbisyo, hindi pa niya alam na bawal yan, aggravating yan. So again, it can be open to various interpretation. Just check the RACS about it. No, it's worded like mitigating / aggravating circumstances, and that the circumstances are provided there. So you can utilize it, no, also in assessing whether the sexual harassment, assessing a sexual harassment case on your given to you if you're members of the CODI. That's why I added 2, because there's a chance that a mere pinch can lead you to be dismissed. And I think that's the point that I'm striking at. Okay, light offenses, there are a lot, no? Surreptitiously looking or stealing a look at a person's part or worn undergarments. Meron pong specific Tagalog term dito no? Namboboso, yan po yan. Okay? Telling sexist or smutty jokes or sending through text or email or similar means, no? May question yan kanina, no? I think safe pa nga yung sagot ko doon. Sabi ko, if it's offensive, no? But here pala, sabi ng light, it's a light offense. Okay? But I think, no, if it's offensive on the part of the recipient, and definitely siya magpo-file ng case eh. So, he or she can file not only based on what she felt, but also based on this offense as a light offense under 2017 RACS. Malicious leering or ogling, display of sexually offensive pictures, materials, or graffiti. Yung pinapakita po yung mga, may mga ganyan, no? Pinapakita yung mga hubad nilang pictures. Okay. Ito common po yan, yung number 5, common po sa gobyerno yan, no? Unwelcome inquiries. Hindi, common pala yung inquiries or comments about a person's sex life, no? Parating tinatanong, kamusta ba ang sex life? Di ba? But take note, no, if the inquiry or comment is unwelcome on the part, no, of the victim, then meron siyang cause of action under a light offense. Ayos na po. Welcome po, Dr. Alvarez, no? Maraming salamat po. Okay. All right. Next is unwelcome sexual flirtation. So here, ito common din po sa atin sa gobyerno, no? We flirt, no, in advance, or we do our positions. But the operative word is that it should be unwelcome on the part of the victim or the alleged victim here. Because if it's welcome, that can be a defense on the part of the perpetrator. Siyempre, welcome yan, in-accommodate po pa nga yan, ganyan. Persisted, unwanted attention with sexual overtures. So ito yung paulit-ulit, no, o persistent na bigay ng unwanted attention na may halong sexual overture, so that can be a light offense, right? And the last light offense is unwelcome phone calls, all right, with sexual overtures causing discomfort, embarrassment, offense, or insult to the receiver. Now again, the penalty can be reprimand or fine, to suspension, to dismissal. Why? Because I'm not removing the fact, no, that circumstances can still be considered to either mitigate or aggravate the penalty of a given offense. It's up to the CODI and the disciplining authority actually, but that is what's provided for by RACS. All right. By RACS, it was provided that in a work-related environment, there should be representation, at least one, from the management, the union, which is accredited, second-level employees, and first-level employees. In an education or training environment, there should be one representative from the admin, teaching, non-teaching, students, or trainings. And third, as to the term of offices, the agency can formulate its own rules, no, to govern this term, which should not be more than 2 years. Okay. The head of office, take note of this one. I think meron po mga tanong kanina niyan, no? Who fails to create a CODI shall be charged with neglect of duty. Section 3, 2017. Now, this should be also connected or correlated to CMO number 1 series of 2015, which states the same. Okay? So, in other words, no, the thrust of the policies of sexual harassment is to really, no, direct the heads of institution to create a CODI. Diba? It's clearly provided for by the law. In fact, aside from provided for by the law also provides for the possible liabilities. Okay? So yun po ang kahalagahan ng CODI as mentioned in the 2017 RACS and as reiterated in CMO number 1 series of 2015, pursuant also to RA 777. Now, functions of the CODI. Okay? In 2017 RACS, there are only 4 as compared mo sa CMO number 1 series 2015. But it just states somehow the same. No? Receiving complaints, investigate, submit a report with recommendation. CODIs are only recommendatory. Take note of that. No? And lead in the conduct of discussions about sexual harassment within the agency to increase understanding and prevent incidents of sexual harassment. So these are the functions of the CODI. Ito, there's a question a while ago, no, about this one. When can Civil Service Commission have jurisdiction over harassment cases? Number 1, if the agency has no CODI. Okay? So, Sir Moist, kanina, no, you asked about this. If there's no CODI, I advised you to refer to 777-11313. You can also refer to the civil service rules, particularly 27 RACs, and file your case before the Civil Service Commission Regional Office because the agency has no CODI. Okay? If the disciplining authority or the head of the agency is a subject of the complaint. Okay? So the option is to proceed to the Civil Service Commission for this number 2 scenario. And number 3, if the CODI member is subject of the complaint. Okay, subject meaning you can be a perpetrator or a victim or whatsoever, or you can be an accomplice as long as the CODI member is a subject of the complaint. Walang sinabi kung anong participation, ano? But as long as the subject of the complaint ang CODI member, then Civil Service Commission shall have jurisdiction. And lastly, if there is unreasonable delay to investigate or adjudicate sexual harassment cases. Now, accordingly, unreasonable delay is that if the period lapsed for more than 30 days without justifiable reason. Okay? So, yan po yun. Unreasonable delay sinasabi ng Civil Service Commission as to the adjudication. There can be jurisdiction falling over the Civil Service Commission. Before I proceed with the workshop, I'll just answer one question sent to me privately. I will not name the person. All right. Would there be required valid evidence or proof the complainant to present in the filing of sexual harassment complaint? There's no required valid evidence, no. But of course, we talk about evidence. It is usually asked for by the CODI, no, because I would like to believe that the mechanism of CODI is evidentiary in nature. So the evidence can be the following. No? It can be by way of object evidence. Now, the object evidence is the direct proof of the incident. So for example, yung torn underwear, tattered clothing, semen on the clothes, semen on the underwear, ganyan. Second, there can be documentary evidence. So what we usually encounter is that the documents of screenshots of emails, no, screenshots of text messages or Facebook messages, no. Kasi when we assess a sexual harassment case, lagi po yan may before, no, tsaka after. So sa before, lagi po yan na meron munang way on how they will meet, para ganyan. So the complainant usually establishes the fact that they met, no, on that specific place and time through messages, no, or through Facebook messages or through emails, Viber, ganyan. So those can be documentary evidence. And the third will be testimonial. Yung testimonial evidence, ito po yung mga witness. Now, question, what if there's no witness on the incident? Kasi this happens, this happens privately. The witnesses can be witnesses before the incident or after the incident. Okay, just to establish that really, indeed, no, there's a chance of contact, no, between them on that specific time, date, and place. So the usual witnesses are those upon whom the report was made, no? Like an example, in one case that I handled, sa police. The police served as a witness. So isa naman sa rape case within the HI, sa doktor. Siya kasi yung nakakita Siya yung na-examine initially, no, nung isang rape case. So those are the witnesses that can be utilized. So as to the required valid evidence, the validity can be appreciated by the CODI, but those are the kinds of evidence that can be utilized as an attachment to the complaint when you file a sexual harassment complaint. Wala po talagang yung dekahon, no? Yun lang po talaga yung mga common evidence that I meet, I see, and I use, no, based on my experience. Okay, there's another one. Hindi ko na po sabihin din kung sino. How about for private institutions? Well, the private institutions are not covered by the RACs, no, but there is still CHED Memorandum number 1, series of 2015, which can serve as the guidance, no, for harassment incidents happening within the private institutions. And of course, the laws of RA 1131 and 777 does not exempt the private institutions for criminal liability. For admin liability, I think CHED Memorandum number 1, series of 2015 will suffice. Okay, from Ma'am Ermelina, is there a required number of investigations before this issue? Ayan, that's a good question, no? Of course. Okay, kung of course, based on my perspective, I strongly believe that investigation should be exhaustive, no, because you should not you should you should really trash out every issue before you recommend. No? For me, as a CODI member before and as a hearing officer also, there should be proper exhaustive investigation. Why? Because commonly in sexual harassment incidents, no, we're talking about careers, no? We're talking about the lives of people and their professional standing or reputation. So I believe it's only proper that we really dig deep, no? Hindi yung ano lang, yung magbabasehan mo lang kasi para sa akin kulang yun eh. That's why you're members of the CODI, you should properly look at it deeply. Okay? So there's no required number, but the investigation should be at that number whereby you're really convinced, no, of the recommendation that you made. Okay? So you should not let any stone unturned. Leave any stones unturned, no? Kasi that's the essence of being members of CODI. Lives, careers are at stake there. No? So there must be we should give also due dun sa mga ganong klaseng scenario. Okay. From Capital University, what would be the consequences if the institution failed to create a CODI? Is there a required time frame? Okay, the first question, I think that was discussed a while ago. CMO number 1 and the RACs provided for that the head of the institution, the head can be liable for neglect of duty, which is punished under 2017 RACs. No? The admin liabilities is either serious neglect of duty or gross neglect of duty pala, no? Or meron pang isa. Gross neglect of duty saka isa pa. Serious neglect or gross neglect of duty and another one, a lighter one. Okay? A required time frame or deadline of creation was provided for in RA 11313. The provision there was that the CODI should be created by agencies within 150 days from the effectivity of the law. The law was made effective, I think, August 2019. So supposedly, all of you out there have already created your own CODIs. No? Okay, Medina Foundation College. CODI members include student org, especially LGBTQ. Do you have to include students? Okay. The requirement of the law is that you should have representatives from student 3. Now, if the CODI members already include student orgs, you can accommodate more because the law provides that there can be at least one. Okay, so there can be, if they're already student org members, you can accommodate additional, no? So hindi lang po isa. And that is regardless of whether you're face-to-face or you're remote, no? Kasi yun po ang requirement po natin. Mayroong CODI membership, may representation dapat ang student 3. From Moist, okay, balingasag. Does an incidental report can suffice as a mere evidence for the sexual harassment case? Yes, that can be an evidence, but I think there should be more. No, because the record, kailangan pa po, no? Baka kulang kung yan lang. No? So dapat meron pa pong additional. So pag kulang at yan lang, baka kung yan lang talaga, no? Sabi ng CODI parang hindi kami masyado convinced, no? Kasi if really indeed the incident happened, then why is there only incidental record? Okay? Yun po. Alright, welcome po sa mga nagtanong. So hopefully you will still participate in our discussion later on. Nabawasan naman po ang ating participants. So I hope that it's not because of me. Okay. So for the mini workshop, you should assess the case provided for. Now based on the RACs. No? Alright. A male supervisor, A, touched the private part of B, his co-supervisor, and the latter welcomed the same. Okay. A, male supervisor A, touched the private part of B, his co-supervisor, and the latter welcomed the same. The question is there sexual harassment under 2017 RACs? Type your answer and explain in our chat box. Okay, we'll check your answers. No, with consent. No, 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 mutual consent. Okay, correct. The answer is none. No, because the operative word is unwelcome. So here, welcome. What about the issue that both of them are supervisors? What about the issue that both of them are supervisors? Will that matter in 17 racks, 27 racks? Okay, regardless. Because in 27 racks, the issues on authority, influence, and moral ascendancy will not be important anymore. Okay? Because peer-to-peer sexual harassment can happen under this specific provision, correct? In fact, even students can harass their faculty members in the provided provision under the 2017 RACs. So thank you po sa mga nag-answer. Next. A, male supervisor inquired about the sexual escapades of B, his co-supervisor, to the shock of the latter. Na-shock siya. No? Is there a case of sexual harassment under 2017 RACs? Yes, of course. No? Dahil nga po, in both scenarios, it should be unwelcome. Okay? So this one, it brings discomfort, correct? And it is unwelcome on the part of the letter B. Okay, next. Differentiate that one from this scenario. A male supervisor A inquired about the sexual escapades of B, his co-supervisor, to the excitement of the latter. Natuwa pa. Tuwa pa, no? Kinwento pa. Okay, done. Again, the operative word is that it should be unwelcome. Okay. Excited kaya. Exciting none. Okay. So, very good. Next. Ito. A male subordinate masturbated in front of his female supervisor B. Okay? Is there a case of sexual harassment under 2017 RACs? Okay? Meron ba? Nag-masturbate? Meron ba yan? Yes, there is. What about the issue that the perpetrator here is a subordinate and the victim is a perpetrator? Will that matter under 2017 RACs? Yes, it will not matter. Again, wala nang authority, influence, or moral ascendancy dito, no, sa 2017 RACs. Next, a male subordinate masturbated using a fake penis in front of his female supervisor B. So kanina, using his penis, dito, a fake penis. Will that be considered as an harassment act? Yes, the effect will still be the same. Okay? And regardless again of the fact that the perpetrator is a subordinate, and the victim is a supervisor. Okay, very good. All right, next. A male employee calls his female co-employee every middle of the night to ask about the color of the underwear of the latter. Ano yan? Tumatawag, no? Okay, the answer is yes, no? So, sexual harassment, can it occur outside of the premises of the workplace? Can it happen through phone calls? Yes. Okay. So there is sexual harassment under RA, under 2017 RACs. Another yes. All right. Now, how about this one? A male employee sends through Facebook Messenger of his female co-employee every middle of the night to tell her the color of his underwear. So kanina, nagtatanong siya, ano bang kulay ang underwear mo? Ngayon naman, etong kulay ng underwear ko. So is there a sexual harassment act under 2017 RACs? Yes, there is. Can it be done through the use of technology? Yes. Can it be done even outside of the premises of the given workplace environment? The answer is yes. Yes na yes, sabi ni Ma'am Lani. Alright. Okay. So maraming salamat po sa inyong lahat. I give you a warm round of applause. No, thank you po sa mga nag-participate. No, I hope that the 227 participants will still participate in our discussions later on. Okay. Before I proceed with the last law, I think I can accommodate questions. Before we proceed with the Safe Spaces Act. You are very calm in discussing on the topics. Opo, maraming salamat po. Sanay na po. Are there any questions, reflections, thoughts, realizations, no, that you can share? Welcome po, Ma'am Fe. Meron po ba tayong mga, kahit hindi po question, any thoughts, reflections, realizations that you were able to gather in the course of our, yes. Thank you, Ma'am Ermelina. No, we have to be careful with our act. That's correct. I think it boils down with that, no? That we have to be careful, no? Kasi there are established laws, no, upon which we can be made liable, no? And one of the important parts of being careful is also be aware. We should be aware, no, of the laws that are there and the rights, no, of our people are in our surroundings, no, so that we will not be able to trample on them. And that's one of the messages of sexual harassment. Okay, accommodate one more. How to be you po, attorney, sana all come. Thank you po, Sir Aljun. Thank you so much. Welcome po. Ayan, I have a question sent to me privately. I will not name the sender. Attorney, how does acts of lasciviousness differ from sexual harassment? Okay. Acts of lasciviousness, first, is a criminal act, and it only talks about the malicious or intentional touching with the lascivious conduct. So it covers yung panghihipo na the purpose of which is sexual gratification. So hinipuan mo lang. Wala ka pang intent to have sex with the other person. Just hinipuan mo lang siya. Trip mo lang mang chancing, ganyan. So that's acts of lasciviousness. So that's only one important part of sexual harassment. No? Kasi pag sexual harassment, it can be done verbally, it can be done by way of a forced sexual encounter. Yung acts of lasciviousness, yun yung panghihipo lang. No? So isang ano lang siya, isang bahagi lang siya ng sexual harassment. There are a lot of things to consider when we talk about sexual harassment because it covers sexual advance, it covers demand, request, or requirement for sexual favor. In fact, it also covers verbal or physical behavior of a sexual nature. One of which lamang po yung acts of lasciviousness. Okay. Thank you po, attorney. Welcome po. Thank you po, attorney. We should be extra careful. Correct, no? Totoo po yan. Ayan, meron pong question. Attorney, what if the act of sexual harassment done outside of the institution with the participation of faculty and student? Can CODI assist to file a case against to the alleged suspect? Okay. All right, this is a very ano po tong question na to, no? Usually commonly na ano po yan na na-encounter natin na question when we do lectures on CODI, no? Kung mag-a-assist ba ang CODI? Okay, I will answer in this manner, no? I think it's best na hindi na po ang CODI mag-assist, but the established mechanisms na binabanggit ko kanina should be the ones to assist. Diba, if you remember, kanina sabi ko sa HEIs under CMO number 1/2015, the head of institution may adopt measures or may adopt mechanisms on how to support. Okay, kasi po kapag po CODI ang nag-assist, alam ko po iba sa inyo CODI members, baka pumabalikan kayo, no? Kasi there are cases whereby the CODIs can be subject to inhibition dahil tinulungan mo yung complainant. Okay, the respondent can use that against you, stating that you are already favoring, no, the complainant. No? Kaya nga po, yun din po yung reason bakit po nagkaroon po ng mandato, hindi naman mandato pero provision under the CMO, which states that no, dapat merong support mechanisms, no, like for legal support, for counseling support, para po maka-assist dito po sa mga biktima so that the CODI will remain impartial or appear to remain impartial. No? Kasi nga po, kapag po may tinulungan kayo dyan, no, that can be used on the ground that the CODI is partial. Okay? Siguro at the outset, upon filing the complaint, we should be impartial apart from appearing to be impartial to both parties so that we are safe. Okay? Okay, yun po yung sagot ko dyan sa question ni Miss Claveria. It's a very good question. No? I think I encountered that a lot of times. Attorney, can we ask a copy of your topics? Opo, I actually provided already a copy to MSU-IIT. So perhaps you have some sort of coordination later on. Okay, meron po ulit through through message. I will not again name the sender. How about the mentor is doing it in the midst of all other students playing safe? In the midst of other students. Kapag po kasi usually harassment happens privately. So kapag po may other students, I think it will favor the complainant because there can be lots of witnesses to the act. So if the mentor is doing it in the midst of all other students, then that can work in favor of the complainant because these students can be utilized as a direct eyewitness to the incident. So although playing safe siya, yung mentor, still, the fact remains that these students can be valid eyewitnesses to the incident, which can reinforce the case to be filed. Okay po. Sent again privately. Attorney, can this be applied or charged against an employee from other agency? Bale, the offender and the victim at the same agency. Okay. Kapag po ganyan ang senaryo, hindi po yan maaabot ng CODI, no? Kasi meron po sa ibang ahensya ng gobyerno. Kapag po ganyan ang senaryo, ang i-apply nyo na po dyan, yung pong ating general laws of RA 11313 and RA 777. Hindi na po siya ma-admin kasi hindi po abot ng CODI yon. What the CODI can only cover are the constituents of a given agency. Kapag outside yan, I think it's best that you rely on RA 11313 and RA 777 for that person to be made liable. Okay? Yun po. Hugging and touching students, yes, correct ma'am. Still, sabi ko nga po kanina, still, it can be, used against the hugger and the toucher because other students have a full view of what he or she is doing. Okay? If the hugging and touching, if the hugging or touching makes the students, feel harassed, intimidated, humiliated, annoyed, or harassed for that matter, then he or she can file a case alongside the testimonies of the other students who are witnesses to the specific acts of hugging and touching. Ay, sorry, hindi nyo pala nakita yun, pero kasi nag-follow up yung comment na kanina about dun sa the mentors doing it in other students. So, sinagutan ko lang din po. Okay, opo, ma'am, nagpadala po ako sa MSU-IIT. So I hope that they will be given later on. Okay, from Mr. Greg, A part-time instructor, B, a student was sexually abused by A. When the case filed, A was no longer, okay, good question. All right, the answer here is this, if the act is committed while A was still connected in the institution, then the case can still prosper within the CODI. Because the concerned incident is when both of the parties were still connected to the institution. All right? So, ang hope lang natin is that before A will not be connected anymore, is that there can still be some sort of still a requirement prior to leaving the institution. Like for example, nag-retire yan, may clearance yan bago makakuha ng GSIS benefits. So, pwedeng iharangin yun on that matter. Halimbawa naman, yung si A ay aalis. So, may mga kailangan yan na credential. So, pwedeng maharang doon. Wag lang talaga sana yung walang-wala na talaga. Pag walang-wala na talaga, then, labas na po tayo. We can rely to RA 11313 or RA 777 for that matter. Labas na po ang CODI dyan pag ganun mangyayari. Kasi wala ka na iba remedy kundi yun eh. Okay? So, but the thing I'm driving at is that whether the perpetrator will be outside of the institution, what matters is that the act happened while the perpetrator still was in the institution. Yun po yung mahalaga. And that's what counts. Okay? What are the grounds wherein a member of CODI would have to recuse oneself? Okay. This is actually provided for in RA 11313 whereby if the CODI member is connected or related to any of the parties concerned. No? So the member of the CODI can voluntarily or by way of a motion from the parties or by way of a motion from his or her fellow members, no, of inhibition on his or her part. So isa po yan, yung pong connection or relation by affinity or by consanguinity. Mamaya po i-discuss ko po sa RA 11313. Okay, welcome po. Marami po nagpapasalamat sa private chat. Okay, so I think we're ready to discuss this final law. Ito pa pala. Sige po, from City College of El Salvador, can the accused file a countercharge in court? Yes, of course. No, the crime can be perjury. No, in the next webinar that we'll be having, I will discuss to you the procedural requirements, and one of which is that the complaint must be notarized. No, so by way of it having notarized, no, the complainant swore to an oath, and if that complainant provided untruthful statements despite being on oath, there can be a crime of perjury, which the accused or the respondent can file as a countercharge in a court. Actually, hindi nga countercharge eh. Pwede nga po yung charge mismo eh. Kasi wala pa naman reklamo eh. So, countercharge mismo sa court po yan. Okay? Perjury can be one. Okay, meron po ulit nag-chat sa private. Okay. Attorney, what if employee A, B, C, D, and E are talking? And employee A commented on employee B that she looks lami-on. In Tagalog po ba ito ay lami-on, masarap? Ano po? Tama po ba? Saan siya na po? Yan. And it became a laughing matter to the group. Will it fall to SH? Okay, the answer is if B felt that comment is or made her harassed, uncomfortable, humiliated, okay, all right, that can be falling under, that can be a charge of sexual harassment. Again, because of what I was mentioning, all these laws rely on the perspective of the victim. So the verbal advance, the demand, request, or requirement, or the behavior, although the perpetrator will say that it's innocent or it's not intended to harass, but if it is harassing on the part of the victim, there can be a charge of sexual harassment. Okay? Yun po talaga yun eh. Kasi yun pong unwelcome, unwanted, it all falls within the perspective of the victim. Di po ba? Kasi kung wanted yan, kung unwanted yan, saan po yung makakaramdam nun eh? Okay, so logically, common sense will dictate that the perspective of the victim will be the one to matter here. All right? So another question, dagdagan ko po yung question nyo, what if naman kung talaga namang panloloko yan, kung talaga mang niloloko lang at wala talagang intention to harass? That can be a defense. All right? So here, A, C, D, and E can propound a defense that it was just a joke. Pero sabi ko nga, it will all boil down to the fact that CODI, the disciplining authority, the courts are all evidentiary. So B will have to prove that she was harassed by virtue of that joke. That incident happened and that she felt that way. And also A, C, and D, and E will have to counter-prove that was only a joke. Yun po yung pag-aaralan ng CODI dyan. Okay? Pero ang punto natin dito, doon sa filing ng case. The filing of the case will rely on the victim or the complainant based on his or her own perspective whether or not the act of harassment happened or he or she felt that manner. Okay. if the incident happened outside the campus, can CODI still investigate the case, sir? Yes po, di ba? Like what I was mentioning, no? Sexual harassment can happen even outside, no, of the premises of the campus. Saan nga po ulit yun? Kahit saan sila magpunta, if the parties are present because of their functions. Third, kapag po sa mga official functions. Fourth, kahit po naka-OB or official business ang mga involved. Fifth, kapag po sa mga conferences. Sixth, kapag po phone calls, text messages, or any other electronic means. So CODI can still investigate. Why? Because still sexual harassment happened within your constituents. Okay. Ito po, from San Agustin Institute of Technology. Attorney, what if the faculty alleged is from one school and the complainant is from the other school? Okay, which CODI will investigate? Ito, mahirap tong question na to, no? Alright, actually po kasi, no, CODIs are only functioning based on their own respective institutions, no? Alright? So now, kapag po ganito scenario, if the one is in another institution and the other belongs to the other, I think the proper thing to do is not to rely on the CODI anymore, but go outside of the institution. Okay? Kasi mamaya, itong CODI na to sa isa, i-dismiss yan kasi hindi naman part ng constituency ng isang school eh. Yung isa, di ba? So the rule is that both constituents should be belonging to the institution for CODI to function and to investigate. Alright? Otherwise, ay sa labas na lang po tayo para sure po ang hustisya or sure ang ating relief or redress. No? Okay? From MSU-IIT, what is the time allotted for the accused? Ayan po, ma'am, i-discuss ko po yan next week. No? The time allotted for the accused to answer and the period for investigation of the CODI. Okay, because next week we'll focus on the procedural requirements. All right, but for now, I can answer it's 10 days. Okay? All right. Thank you po. Thank you. Okay. So are we ready to discuss RA 11313? Can I have a 2-minute health break? No? 2 minutes lang po. Moderator, Miss okay lang po ba?
Yes, sir. Okay lang po.
All right. So excuse me for 2 minutes. Thank you. We'll just stretch our legs.
Tech team, can we perhaps play a music po? Sir Jabe, can we play a music? Thank you.
Good afternoon, everyone. Kindly answer our pre-test because that will be the basis of your one of the basis of your e-certificate, and you will have your post-test later also. Thank you. For easy recognition also, kindly change your Zoom name to the name of your organization underscore then your complete name. Thank you. So that our speaker can recognize your school or your institution. Thank you.
Okay, can we proceed? Are the 227 Zoom participants still present?
Yes, sir, you can proceed.
All right. Okay, thank you for those who responded in our group chat. Okay, so the last law that we will be talking about this afternoon is on RA 11313, or the Safe Spaces Act. To begin with, this 11313 is actually based on the constitutional provision that we have, that the state shall value the dignity of every human person, and that the state guarantees full respect for human rights. Again, like what was provided for in RA 777, sexual harassment is considered to be, or deemed to be, a violation of human rights. And that's why the state frowns upon. In fact, by virtue of 777, declares the act as lawful and cannot be tolerated at all. Now, from the Constitution, it actually is in harmony with what is provided for by existing laws. No? We have an existing law of RA 7192, or the Women and Nation Building Act, which states that the state recognizes the role of women in nation building, and that there should be fundamental equality before the law of women and men. Okay? So apart from the constitutional provision, it's actually based also in the existing laws on women and sexual harassment. Now, importantly, one of the bases of this law is RA 777, which states that the state recognizes both men and women should have equality, security, and safety. Now, in addition to that, okay, apart from the identified environments whereby sexual harassment can happen in 777, there are additional places wherein sexual harassment can happen in 11313, where in streets, public spaces, and online. Okay? So that the addition of the public spaces sexual harassment and online sexual harassment has been added in connection to 777, which only provided for workplace, education, and training environments. All right. Now, some important definitions that must be known in 11313. One is stalking. Now, stalking, this actually is provided also in RA 9262. Okay, the act of stalking, but 9262 focuses on violence that are occurring within domestic relationships. So that's a context. But here, it was adopted in 11313 and states that it involves a conduct involving repeated visual or physical proximity, non-consensual communication, or even a combination thereof. In stalking in 9262, it only focuses on the proximity. It covers a situation whereby yung asawa mo like ka sinusundan, o yung boyfriend mo like ka sinusundan, yun yung stalking doon. But here, in 11313, apart from the repeated visual or physical proximity, it also covers non-consensual communication. So, ibig sabihin, kinakausap ka pa na ayaw mo, or a combination thereof. And that these acts will result to fear for one's safety, okay, or safety of others, or it causes suffering or emotional distress. That's what stalking as punished in RA 11313. All right, catcalling was also defined in this law. Before this law, catcalling has been known to just consist of sipol, di ba? Yung wolf whistling lang yan. But here in this law, it covers a lot of things. It covers unwanted remarks. Okay? It also covers wolf whistling. And it covers this kind of remarks, the four kinds of remarks: of misogynistic, transphobic, homophobic, sexist remarks or slurs. The definitions of those will be discussed later. So in connection to stalking in RA 9262, and in relation to stalking here in 11313, there's this concept of cyber stalking. Okay? like what I was mentioning a while ago, that one of the environments that has been considered for sexual harassment in 11313 is an online environment. And therefore, the acts, no, that are happening online can be covered by virtue of this law. Same with this concept. No? Stalking 9262 added 2 by 11313 now in the context of sexual harassment, and now can be done through an electronic media in which online communication takes place. No? Of course, in an online environment, no, communication can be done, no, through the internet. In fact, I think some, if not all, or most, if not all, social media platforms have communication tabs with them. No, so therefore, stalking can easily happen, no? Or cyber stalking can easily happen. Okay, so this is one kind of sexual harassment that has been defined, no, by virtue of this law. This is the first law that defined this kind of sexual harassment, yung gender-based online sexual harassment. Now, flowing from what I was mentioning a while ago, that an online environment is an added place where sexual harassment can happen, in connection to this definition, that it pertains to an online conduct whereby, no, targeted at a particular person that causes or likely to cause what? Distress, no, mentally, emotionally, psychologically, or fear of a personal safety, or even sexual harassment acts, or even unwanted remarks, comments, and threats by way of uploading, sharing of one's photos without consent, all right, video and audio recordings. It also covers cyber stalking and online identity theft. All right? Before, if these acts happen, no, yung uploading or sharing of one's photos without consent na yan, there are several laws that can be covered, that can be tapped. No? You have RA 9995 or yung Anti-Photo and Video Voyeurism Act. Now, if this is posted, for example, in social media, if it is destroys the reputation of another, there can be cause of action for RA 10175. Now, meron na siya ngayon, direkta in one specific law of RA 11313, which covers these acts that were previously covered by two different laws. If the uploading or sharing is within the context of a relationship, there can also be a cause of action under RA 9262. Pero dito walang ganun. So, ibig sabihin, those three laws the acts there can be covered already by 11313. All right. Now we go to the definition of the slurs, which I was mentioning a while ago, that falls under the definition of catcalling. No? So homophobic, misogynistic, sexist, and transphobic. Now the remarks, all of them indicate fear, no? Indicate hatred or aversion. Yan po yung common definitions ng apat na yan. But for homophobic remarks, the fear, hatred, or aversion pertains to persons who are perceived to be or actually identify as what? Lesbian, gay, bisexual, queer, and such other persons of diverse sogi, or towards any persons who perceive to or actually have experienced same-sex attraction. So here, we talk about homophobic, we're talking about the sexual orientation of the person upon whom the remarks were made. Okay? So if the statement again is indicative of fear, hatred, and aversion, it pertains to another person's sexual orientation, that can be falling under homophobic remarks, which falls within the definition of catcalling, punishable under RA 11313. Now, misogynistic and sexist remarks somehow are similar. Why? Because both of them, no, the targets of these remarks are commonly women. For misogynistic remarks, no, it pertains to statements which are indicative of the feeling of hating women, okay, or belief that men are inherently better than women. All right, for sexist remarks, it talks about the prejudice, stereotype, discrimination on the basis of sex, which again is typically against women. Okay, for transphobic remarks, now this pertains to the fear, hatred, or aversion towards persons whose gender identity and or expression do not conform with their sex assigned at birth. So here it talks about, no, yung ating transgender individuals, no. that pertaining to their gender identity or expression. So if the remarks, are thrown, for example, in a street, in a public space, or even online, the law that can be referred to is RA 11313. Okay, so here's a picture of what a public space is all about. No? So public spaces can be roads, alleys, parks, no? But it can also be public utility vehicles or private vehicles that are offered to and can be accessed by the public. It also covers private establishments, which are again open to and can be accessed by the public. So basically, it covers a whole lot of space or public areas and even private areas as long as it is open to or accessible to the public. This is the definition actually. So what I was mentioning was actually here. All right. So take note, no, PUVs, PUJs are covered, even private vehicles are covered. Usually those who are doing app-based transport network vehicles, like for example, your Grab, your Angkas, no, Uber. Okay, we now go to the first category, no, or kind of harassment as mentioned or as provided for by RA 11313, the gender-based streets and public spaces sexual harassment. Now, the way I will be discussing this, later pala yun, sorry. Before we proceed with discussion of the important components of this act of sexual harassment, please watch this video. And before you watch this video, take note, no, of course, the video that I will be showing is just merely for education purposes. So there might be triggers here. No? So I'm warning you, no, but I hope that actually the reason why I am sharing this video is to contextualize what I will be discussing later on. Okay? All right. So here's the video. Please tell me if you will not be able to hear it.
Magandang araw ang binungad sa akin ng mundo. Bagong araw ng pakikibaka at paglalakbay, bitbit ang pag-asa at pangarap. Hawak ang positibong pananaw, dalangin ng isang makabuluhang araw at makauwi ng maayos sa aming tahanan. Sa araw-araw na paglalakbay, sa lansangan, sa kalye o sa daan, kay ingay-ingay ng mga sasakyan sa pag-ugong at kusina. Walang tigil sa paghuni ang mga makina, walang kumpay at hindi dumitigil. Sa bawat kanto, sa bawat kalsada, mapaabanida o maliit na eskinita. Patuloy din ang seksistang pagtingin at pagtrata sa akin. Kailangan mo ba talaga akong batiin ng
Hi miss, good morning beautiful.
kasabay ng tingin na para bang ako'y hinuhubaran? Kailangan mo ba talaga akong sabihan ng
Hi, ang sexy mo naman miss.
sabay ngisi at kindat na sapat upang ako'y kabahan? Kailangan mo ba talaga akong sipulan? Kahit tahimik lang akong dumaraan. Ako, si Juana, si Fatima, si Maria, pati si Magdalena, araw-araw na nagtitiis sa ganitong uri ng sistema. Hindi ito musika sa aming mga tenga. Hindi kami nagigiliw o naaaliw. Hindi namin pinangarap ang ganitong lipunan dahil sa bawat bulong, sigaw at alingaungaw, ang tanging hiling namin ay pagkakataon na respeto ay mangibabaw. Binabalot na kami ng takot. May pangamba sa bawat galaw. Naninimbang sa bawat espasyo sapagkat hindi ligtas at hindi sigurado. Tama na ang paghaplos at pagsulyap. Tama na ang pagtitig at pagdantay na parang kami ay inyong pag-aari o laruan. Kailan ba magiging patas ang mundo? Ang sabi ng pabulong ngunit nagngangalit ang tinig ko. Kailan ba magiging malaya at matiwasay ang lipunan na ginagalawan ko? Sana bukas, sa muling pagbungad sa akin ng mundo, wala nang anumang uri ng pang-aabuso.
Okay, thank you for viewing the video. All right, so I hope I was able to put into context what I will be talking about and also what is being covered by the concept of gender-based streets and public spaces sexual harassment. So here are examples of catcalling. Uy, sexy, ganda mo naman, smile ka naman, hi miss. But for information, not only women are being subjected to this kind of sexual harassment, no, even men. No? Yan. Uy, tingnan mo si kuya, grabe, ducks. No? So if this happens no, in public spaces and streets, then that can be falling under sexual harassment, punishable under 11313. So this is an example of wolf whistling. You will see here. Ito yung common no, sa kalye, di ba? Yung ano number mo, miss? Ito pa. Saan ka pupunta? Sakay ka na. Okay? So this can be covered by yung relentless personal asking of details, which is punishable by 11313, and I will explain that later. Okay. So I will discuss gender-based streets and public space sexual harassment in this manner. I'll first discuss to you the acts and how it is mandated in private establishments, like for example in restaurants, bars, clubs, resorts, etc. Also, how it is implemented in PUVs, no? And also in streets by minors. No? All right, so here are the acts of gender-based streets and public space sexual harassment, catcalling as defined. In fact, the acts constituting catcalling also exist no, as a singular acts no, here of this kind of harassment, no? Wolf whistling, unwanted invitations. Yung unwanted invitations, this is what I was mentioning a while ago, yung saan ka na, hatid na kita, yan. The misogynistic, transphobic, homophobic, or sexist slurs or remarks were defined a while ago. It also covers persistent, uninvited comments or gestures on a person's appearance. Yan. Okay? Relentless request for personal details. Yan yun. No? Saan ka nakatira? Saan ka trabaho? Anong pangalan mo? Ilan taong ka na? Ayan. Okay? Statement of sexual comments and suggestions. This can be falling under this kind of sexual harassment. Public masturbation. Now, before this law, public masturbation, there can be possible crimes of unjust vexation or crimes and scandals. No? But here, it is expressly provided for that when public masturbation happens, there is this law that already punishes the act, which is RA 11313. Flashing of private parts, ito po pinapakita po yung mga are, no? Groping, no? Ito po yung pangdadakma. And the last kind of act, I think, no, encompasses a whole wide array of acts, no, because it covers any advances, all right, whether verbal or physical, that is unwanted and has threatened one's sense of personal space and physical safety. Now, these acts, if committed in public spaces like what I was defining a while ago, example of which are alleys, roads, sidewalks, and parks, and that can fall under gender-based streets and public spaces sa sexual harassment. Okay, my question. How about if the person doing the masturbation in public has a psychological problem? Okay, the act itself is punishable, but the psychological problem should be proved, no, on the part of the one who performs the act. Okay, it's clear, it's very clear here that public masturbation is punishable by law, by 11313. What that person can do is to present proof that he has a psychological problem, but it will be forwarded by way of a defense already. When you say it's a defense, there's already a complaint filed. And because of the rights of due process on the part of this person, he or she can provide that proof. He should provide that proof so that he or she can be absolved of any liability because it was a psychological problem. Okay, thank you, Sir Joey. All right, now, apart from the acts, no, there are specific mandates on the part of private establishments on what they should do, no, in connection to preventing, okay, this kind of acts or complying with what RA 11313 provides. Number one, the law provides that there should be or they should implement a zero tolerance policy. Okay? And there are three measures upon which they will be able to do so. One is measures to prevent, second is measures to address, and third is measures to enforce. As provided for by the IRR of 11313, the measures to prevent are as follows. There should be clear, visible warning signs. And the warning signs should be readable, nababasa, understandable, naintindihan, conspicuously posted, nakikita. All right? Second, there should be an anti-sexual harassment hotline number and can include the nearest police station's number in bold letters. All right. Third will be at least one anti-sexual harassment officer who can be designated to receive complaints. Okay. Now this ASHO must be competent and knowledgeable on gender-based sexual harassment. Apologies, Miss Hegonia. No? Sorry, I just based the sex on your name. Sorry po, ma'am. Okay? So this ASHO must be competent and knowledgeable, no? And that should be able to provide assistance to the victims. Okay? This is one important requirement because of course, again, no, these things can be addressed by proper complaints. And if the complaint pa lang, sabi kagad ng ASHO, ba't ka kasi maikli ang suot, no? O ba't kasi ano yan, maikli ng shorts mo. Patay tayo dyan. It is, kumbaga, at the onset, no, baka hindi na mag-push forward o baka hindi na magreklamo. No, itong nagreklamo kanina. No? Alright, so it's very important that the recipient of the complaint should be knowledgeable on how to handle these kinds of things. Measures to address, okay? Now, here, in this kinds of measures, this private establishment should provide assistance to victims. How? Asterisk. Accompanying the victim to the police authority. So that's one kind of assistance that the owners of the establishments can provide, by way of coordinating with the local police authorities. There should be CCTVs, and apart from having CCTVs, they should make the footage available upon order of the court. Second is the provision of a safe, gender-sensitive environment. Now, how? By having a secure private area when victim can narrate the event. So there should be a private area whereby the incidents can be properly reported. No, otherwise, hindi rin, kulang din, no, kapag hindi kinuwento buo. Okay, and lastly will be development of protocols to be followed. The protocols can include filing or can be made online. So the point here is that there are options upon which, or there are ways on how to address sexual harassment. Yan na po yun. Sabi ng IRR of RA 11313. Now, last will be the measures to enforce. So for enforcement, the security guard plays an important role. Actually, the security guard or any person who has witnessed the crime, what can they do is to conduct a citizen's arrest. Meaning to say that the warrant need not be waited anymore. Okay? Because upon performance of the act, upon witnessing the crime itself, the security guard or any person can arrest and or apprehend the perpetrator. PNP is mandated to issue guidelines to deputize security guards, and the absence of a warrant can be, or the arrest can be made even without a warrant, subject to the rules on warrantless arrest, of course, as provided for in the rules of court. Now, for this to properly be enforced, there should be awareness, and awareness seminars, and in fact, the awareness of the law should be forming part of the topics or modules for trainings before security agencies and security guards can renew their licenses. Okay, now for GBSH and PUVs, the law activated the LTO and LTFRB, because of course LTO can cancel the licenses and LTFRB can perform actions on the franchise. Okay, now if the perpetrator is the driver, all right, the law provides that it shall constitute as a breach of contract of carriage. Ano ba ito? This is actually a legal term whereby the passenger and the operator enters into a contract upon payment, that the operator will bring the passenger safely to his or her destination and also his or her goods. Now, kapag siya ay na-harass, okay, it's deemed to be that the contract of carriage is already breached. And if there's a breach of contract of carriage, breach of contract, there is a corresponding civil liability or damages. Now, if there's a case of breach of contract of carriage, there is a presumption of negligence on the part of the owner or operator. So kumbaga lamang ka na ng konti kasi presumed negligent yung kalaban mo, no? Which is the operator. Okay, the driver is the employee of the operator. Now, it renders the owner or operator solidarily liable for the offense of the employee. So even though the operator is not the one who performed the sexual harassment act, it would appear to be that he or she will also be liable civilly based on this breach of contract of carriage as provided for by RA 11313. Now, if the perpetrator is any person within the PUV, then the LTO, LTFRB may suspend or revoke, no, the use of the driver's license. But here in this scenario, there should be proper filing of an admin case before the LTO. Okay? Sabi dito kasi, this can be done subject to LTO's own admin procedure on suspension or revocation of driver's licenses. Okay, but if the case is filed in appropriate court, the court, no, on its own can order the cancellation of the license or revoke the franchise. And of course, upon the directive of the court, the LTO and LTFRB can conduct such cancellation, suspension, or revocation. Now, if the court does not mention it, no, the court decision can just form part of the evidence to be filed for the complaint to be filed before the LTO for the revocation or the use of license to happen. Now, if the harassment happens in streets and public spaces and committed by minors, no, the remedy is to proceed to the DSWD. Okay, because the DSWD is in charge to take the measures, no, in connection to RE 11313. But the program, the diversion program, shall include age-appropriate GST or anti-sexual harassment activities. So these are the acts punishable and the penalties. You will see here that the acts punishable of wolf whistling, catcalling, slurs accommodates 3 offenses, no? First offense, second offense, third offense. Now you will see here that the monetary penalties are quite low. For fine here, 1,000 lang. Okay. Dito 3,000, dito sa third offense 9,000. But you will see here that for first offense, no, there's a requirement that there should be 12 hours of community service and attendance to a gender sensitivity seminar. So pag ang standard APCW, the gender sensitivity seminar should be 3 days, no? So I believe that a lot of time will be spent on learning on how to not harass, no, and by serving the community, apart from considering the low monetary penalty. So that's for the first offense. Second offense can lead the perpetrator to be imprisoned for 6 to 10 days or fine of 3,000 pesos. So imprisonment of 1 day is inconvenient enough. No, what more if it will be for 10 days? No? Third offense is imprisonment for 11 30 days, so reaching for at least not more than a month, and fine of 10,000 pesos. So these are actually this is what the acts of gender-based streets and public space sexual harassment looks like. No, it accommodates numbers of offenses. Now, if the acts include those that are like public masturbation or exposure of the private parts, no, groping, and similar lewd actions, again, it accommodates offenses. No? So for the first offense, fine is 10,000 and community service of 12 hours apart from having a gender sensitivity seminar. Second offense is 11 30 days or a month, no? Or fine of 15,000 pesos. And third offense is 1 month and 1 day to 6 months or a fine of 20,000 pesos. And last categories of acts include those of stalking, and if accompanied by touching, pinching, or brushing, or stalking alone, no, can lead you to several offenses again. The first offense, second offense, third offense. At the first offense, the imprisonment can be already 11 or 30 days or a fine of 30,000 pesos. The community service is already gone, but no, the seminar is still there. All right. Imprisonment, second offense is quite high. No, imprisonment is 1 month and 1 day to 6 months or 50,000 pesos. Third offense is imprisonment of arresto mayor max, or the 6 months. No, 4 months to 6 months or fine of 100,000 pesos. May question po. Just curious, what usually is the community service? Actually, it depends upon the implementing agency here, no? As long as the activity will serve the community, like for example, cleaning, no? That's what usually happens, like cleaning the halls of a given government building, planting, ganyan po. So, yun po yung mga community service. But it really depend on the implementing agency. Here, the implementing agency can be DSWD, no? Can be the LTO, LTFRB. It can be also other government agencies like the police. So, yun po. All right. The next category on RA 11313 is about gender-based online sexual harassment. All right. So before we proceed, I would like to invite you to this video. Please tell me if you'll not be able to hear it.
Sa mundong digital, hindi nyo ako mahahawakan. Wala kayong mapapala, dampiman sa aking labi o haplos ng mga braso hanggang titignan kayo sa malayo pagkat malaki ang distansyang namamagitan sa atin at merong itim na salamin na pumuprotekta sa akin. Pero sa mundong digital, hindi nyo ako tinatantanan. Maya't maya ako ipinagdadalhan ng mga pagbabanta ng paggagahasa, ng mga huwad na kahilingan, malalaswang mga larawan, mga mensaheng wala naman akong kinalaman. Dahil sa mundong digital, ang itim na salamin ay ginagamit ring daan para sa mga karahasan laban sa kababaihan. Sa mundong digital, hindi nyo lang siguro napapansin ang karahasan. Nasa ng dugo, nasa ng pasa, nasa ng pisikal na ebidensya. Sigaw nyong mga mapagduda. Pero ang mga salitang inyong binibitawan ay tumatago sa screen at nakararating sa akin. Pagkat ang pang-aabuso rito, hindi mang pisikal ay pang-abuso pa rin. Kaya't kahit sa mundong digital, hindi nyo ako mahahawakan. Ang babaeng tulad ko ay kaya pa rin saktan. Nagmamarka ang mga salita at ang bawat pagbabanta. Nagiiwan ng takot at pangamba at pagkabalisa. Dahil kung sa mundong digital kaya itong gawin at sabihin, ano pa kaya kung sa mismong mundong ginagalawan natin?
Okay, thank you for watching the video again. No? Just the video is just for academic discussion and purposes. No? There can be triggers present there, and I apologize for that. I would just like to contextualize what I will be discussing henceforth. Okay, so one kind of online sexual harassment is this one, extortion. No? Threats to expose a sexual image in order to make a person do something. So before, we have this concept of extortion, but they added here to accommodate these kinds of acts. This is one example of cyber stalking. Okay, yeah. Cyber sex, okay, it's also punishable under GBOSH or gender-based online sexual harassment. Cyberbullying. No? So this is actually from I think I gathered this from Australia, no? But I can see that most of the acts here are what is punishable under 11313. So yan yung through messages, no, editing nasty images, encouraging someone to hurt themselves, fake social media accounts, no. Ito yung cyber theft, no, pwede ring ma-punish ng 11313, trolling people, hacking. Yeah. All right. So gender-based online sexual harassment cover the following acts. First, acts that use ICT in terrorizing and intimidating victims by way of threats. The threats can be physical, psychological, and emotional. All right. Yes po, I actually provided po with MSU-IIT. Hopefully, through that po, maibigay po sa inyo yung pong copies ng videos. Is actually present in YouTube. No? Those are all PCW videos. All right. Okay. Next, unwanted, no, sexual, misogynistic, transphobic, homophobic, and sexist remarks and comments online. Now, these kinds of remarks can be present publicly or even through direct and private message. Even though it is sent only as a direct message, it's also punishable under GBOSH or even it's posted, no? As for example, a status for that matter that can be falling under GBOSH. Yes po, welcome po, Ma'am Hinosolango. All right. Third talks about invasion of victims' privacy through cyber stalking and incessant messaging. So ito po yung what I was talking a while ago, using apps, no, to track you wherever you may go by way of cyber stalking. Incessant messaging, even pa ulit-ulit na messages, no? Like what I was mentioning, no, that most, no, of our social media accounts have a communication tab whereby this can be done by almost anyone. So if there's an incessant messaging on your part, then there can be a release or redress, no, under gender-based online sexual harassment. Fourth is talks about uploading and sharing without consent of the victim any form of media that contains photo, voice, or video with sexual content. So if the uploading and sharing involves media with sexual content and it is not without it is without the consent of the victim, there can be a cause of action under gender-based online sexual harassment, punishable under RA 11313. So we should look at this also in connection to RA 10175 and RA 9995 about anti-photo and video voyeurism and the Cybercrime Prevention Act. Same goes to the next act of unauthorized recording and sharing, no? Unauthorized recording and sharing of photos, videos, or any information online. So we should also look at it in our data privacy laws that we have right now. No? So there are several laws that are governing, no, this kind of acts or punishing these acts. 6 talks about impersonating identities or victims online. So if you know yung mga fake accounts, no, or pretending that this person is you, whereas it's not you, so no, there's an action for gender-based online sexual harassment here. Posting lies about the victims to harm their reputation. So actually, this is covered also by RA 10175, no, yung pong konsepto ng cyber libel. It's punishable there. But I think I would like to say that what's covered by GBOSH is that if the lies pertain to a sexual nature, like for example, kung yung nakapost online is about you, bawa, ikaw ay yung pangalan mo, no? Isa kang estapador, hindi ka nagbabayad ng utang. So I think the proper law is 10175. Pero yung bawa, ikaw ay isang pokpong, kanino lalaki ka na dumaan, ganyan. I think that falls under 11313 because of the sexual nature, no, of the lies that are posed against, no, the victim. And the last one, actually, I think this is quite different from the previous ones because here, if the act is on filing false abuse reports to online platforms to silence victims, I only see this kind of tool in Facebook, no, whereby you file a report, no. So I don't know if other social media accounts have this kind of mechanism, but no. Anyway, if the filing or the filing of the abuse reports is meant to silence the victims of sexual harassment, then there can be a case of gender-based online sexual harassment punishable under 11313. So these are the acts, no, that are constituting gender-based online sexual harassment or GBO. Now, apart from naming the acts itself, no, the law mentioned about the implementing bodies that should be concerned, no, with these kinds of online acts. No? Like for example, this PNP anti-cybercrime group, in fact, they should already have developed an online mechanism whereby real-time, no, sexual harassment can happen and that they will be able to apprehend the perpetrators. The DOJ should also develop standards and protocols on how it will be able to gather evidence and build up cases. Second body is the CICC of the ICT. Ito ba, yung Department of Information Communications Technology. I think this is one of the new departments in the Philippine government, which now is in charge alongside the PNP, ACG, NTC, and NPC, so that, no, the function is to prepare, no, measures to monitor and penalize GBOSH, and they have the following functions. Okay, and apart from that, protocols shall be developed by the DOJ, PNP, NBI all right, for them to be able to address gender-based online sexual harassment. No? They have these kinds of interagency arrangement because, of course, we all know that the internet, no, makes it hard for proper implementation or enforcement of laws, di ba? The internet provides a shadow of anonymity, no, or shadow of doubt, and if we will connect it to the kind of prosecution that we have in the Philippines, di ba? We have this kind of guilt, evidence of guilt beyond reasonable doubt. So ibig sabihin, for example, for a given case here, kailangan siya talaga ang mapatunayan na siya ang nag-upload ng photo. No? And it's very hard because, of course, the internet provides, again, no, a cloak, no, upon which anonymity can be implemented. So it will be very hard for victims to prove. It's why this kind of interagency arrangement or interagency development of protocols are just in place to address those kinds of issues. Okay? All right. Now, penalties as compared to gender-based streets and public spaces sexual harassment, the penalties here are very clear. There's no accommodation of number of offenses, no? And what's good about these penalties is that it accommodates also the possibility that aliens or foreigners can be perpetrators of these acts, and in fact, even juridical persons or entities. Now, for individuals, the imprisonment is prison correctional or 6 years to 12 years or fine of 100,000 to 500,000 pesos. Now, if the perpetrator is an alien or foreigner, apart from serving imprisonment or fine, the alien should be deported. Okay? Now, if the offender is a juridical person or entity, no, the official shall be liable. So it would appear to be that if, for example, juridical person is a corporation, this can be used to pierce, no, the corporate veil and make the officials liable for the offense. And apart from that, as provided for by this law, the licenses or franchises of these juridical persons or entities shall be automatically revoked. Okay, now both kinds of sexual harassment, no, can be qualified. Okay, now the word qualified it actually means that the penalty will just increase. So if the scenario, no, for example, number one here is when an act takes place in a common carrier or PUV or in app-based transport network vehicle services, like for example in Grab, Uber, Angkas, and the perpetrator is a driver and the offended party is passenger, okay, it becomes a qualified gender-based streets and public spaces sexual harassment. Now, the effect of the word qualified is that the penalty is increased, no, or makes it higher in degree. Second, if the offended party of the victim is a minor, senior, PWD, or breastfeeding mother nursing her child, the act becomes qualified. Third, if the offended party is diagnosed with a mental problem, act becomes qualified. If the perpetrator is a member of a uniformed forces, like for example, PNP, AFP, and the act was perpetrated while the perpetrator was in uniform, the act becomes qualified. And lastly, if the act takes place within government premises that offers frontline services to the public and the perpetrator is a government employee, the act becomes qualified. So the effect of them being qualified is that the penalty becomes higher in degree. Okay, we now proceed with gender-based sexual harassment in the workplace. To our participants, if you have questions, just please don't hesitate to ask your questions in our chat box. No, I just would have to somehow rush, no, because I would want to finish our today's PowerPoint deck. Okay, so next part will be on gender-based sexual harassment in the workplace. But before I proceed, I would like to or invite you to watch this video. Thank you.
Overtime, overtawad. Kahit overwork at sobrang pagod, magpupursigi sa pagkayod. Tanong nila, may energy ka pa ba? Pursigidong sagot ko, kakayanin sir, ako pa ba? Para sa pamilya, magtitiis at magsusumikap para tuwing kinsenas at katapusan, may pambili ng mga pangangailangan. Sa totoo lang, kayang-kaya ang bigat ng trabaho kung matiyaga ka at buo ang loob mo. Kaya lang, isang gabi, tinawag ako ni boss ko.
Pumasok ka sa opisina ko, may papagawa akong trabaho.
Nagkibit balikat, ipinagwalang bahala. Pagkat utos ng hari ay hindi dapat mabali. 5 katok sa kanyang pintuang tila impyerno na aking tutunguhan. 3 dipa mula sa patibong ng lalaking halang ang kaluluwa. Amoy ng sigarilyong kumakapit sa damit, habang sa akin titig na titig, nagpupuyos at patuloy na nag-iinit.
Di ba gusto mong mapromote? Balata mo na sa akin kung isang gabi.
Mabilis ang paglapit niya hanggang sa ako'y mahigpit na hinawakan. Boss, nirerespeto ko po kayo. Huwag naman po sana kayong magbiro ng ganto.
Sandali lang to. Di mo mamamalayan. Paparamdam ko sa iyo ang langit. Tataas ko pa ang sweldo mo. Hindi ba yan ang dahilan kaya panay ang overtime mo?
Dito na ako naiyak at nagsimula na akong magpumiglas. Tumakbo ako ng matulin, kumaripas ng kumaripas, humahangos habang ang luha ko'y tuloy sa pag-agos. 3, 2, 1, 3. 3 taong sa kumpanyang itinuri kong tunay na pamilya. 2 salitang hindi ko pinansin.
Akin ka.
Na akala ko'y biro niyang maituturing. 1 gabi na akala ko sa pelikula lang nangyayari, ang gabi na habang buhay kong ipagdadalamhati. Kanino ako magsusumbong? Kanino ako hihingi ng tulong? May maniniwala ba sa akin? Anong sasabihin ng pamilya ko? Paano kung matanggal ako sa trabaho? Saan ako tatakbo? Paano ko sisimulan ng laban? Dapat pa nga bang lumaban o subukan na lang kalimutan? May mga tao ba akong masasandalan? Papanig ba sa akin ang timbangan ng babaeng nakapiring? May pag-asa ba akong mahawakan ang hustisya? O ipipikit ang mga mata at tatanggapin na wala, hanggang dito na lang talaga.
Thank you for watching that video. So, gender-based sexual harassment in the workplace. I think we have discussed workplace sexual harassment way back 777, as mentioned in 2017 RACS, and now in 11313. CMO number 16 of 2015 focuses on education on related sexual harassment. And we will discuss also education or training related sexual harassment after this specific part. So as defined, gender-based sexual harassment in the workplace can be unwelcome sexual advances, request or demand for sexual favor, or any act of sexual nature, which can be done verbally, physically, use of technology, or through any other forms of information communication systems. So flowing from the definitions of sexual harassment in RACS, in the CMO, it elaborated further by covering also or by specifying the use of technology, which can be also utilized in acts of sexual nature. Now, it qualifies by way of stating that has or could have a detrimental effect on the condition of the employment, education, job performance, or opportunities. Now, it also covers any conduct of sexual nature and other conduct based on sex, which are unwelcome, unreasonable, and offensive. And it also can be done verbally, physically, or through the use of technology and other forms of information communication systems. Okay, and lastly, sexual harassment, gender-based sexual harassment in the workplace can be a conduct that is unwelcome, pervasive, and creates intimidating, hostile, or humiliating environment. Now, in this law, it emphasizes that gender-based sexual harassment can be committed between peers and by a subordinate to a superior officers. The places of sexual harassment or workplaces are also defined as all sites, location, spaces where work is being undertaken or within or outside the premises of the usual place and places of the employer. Now, the duties, as compared to RA 777, the duties of the employer here are quite a plenty. There are only 2, but here there are quite numerous. One is to prevent, deter, or punish the acts of gender-based sexual harassment in the workplace. In the IRR, it was provided that one way to prevent, deter, or punish is to disseminate or post in a conspicuous place a copy of this law. Now, how can the dissemination be done? It should be by way of sending copies of the law through official notices, no? Or means of communications. It can be by way of posting a copy of the law online or in the official website of the workplace. Third, by way of orientations on the law, like what you're doing right now, no? And its rules, and providing a copy of its print electronic form, like a simple FAQs, primers will do, because in this manner you are disseminating the concept of RA 11313 to your respective employees. Okay? Now, these copies of the law should also be posted in workplace areas that are easily visible to employees, especially where they congregate. Now, apart from dissemination, the employer should also provide measures to prevent gender-based sexual harassment in the workplace. Like, for example, conduct of seminars like this, no? You shall be provided to employees regardless of rank and status. Now, this can be also done by way of gender sensitivity, GST, okay, anti-sexual harassment seminars. Okay, and in fact, as provided for by 11313, these kinds of trainings and orientation should form part of the staff development and basic knowledge of the employees. Okay, again, no? The emphasis on the creation of an independent internal mechanism or a CODI to investigate and address the complaints of gender-based sexual harassment. And apart from that, no, there should be development and dissemination of a code of conduct or workplace policy which shall reiterate, no, the prohibition on gender-based sexual harassment, procedures, no, for the internal mechanism. So it talks about the procedures for the CODI. Okay, so it would appear to be that the CODI will not properly exist without this code of conduct or workplace policy, because this code of conduct or workplace policy will provide on the procedures of the internal mechanism that was created. And last is to set admin penalties. Now, the CODI composition has been specified, no, in this particular law. So there should be adequate representation, no? When you talk about the workplace, it should be a representation from the management, supervisory, rank and file, union. Now, here it's provided for that the head of the CODI should be a woman, and that at least one half of the members should be women. Members should be impartial, no, and not connected or related to the alleged perpetrator. There should be proper investigation decision on the complaints within 10 days or less. Due process should be observed. Retaliation from the respondent should be, or the complaint should be protected from the retaliation of the respondent, and that there should be confidentiality to the greatest extent possible. All right? Now, in connection to the duty of the employer, the law also provided for the possible liabilities for non-performance of the duty. So nakalagay dito that in case of non-compliance in the public sector, the employee may file an admin complaint with the CSC. Okay, so non-compliance of duties po yan, no? Like that were mentioned a while ago. Now, if the employer is an appointee, elective official, no, or official of the AFP, the complaint may be filed within their appropriate jurisdictions. For private, no, the duties, the compliance can be, non-compliance thereof can be filed before the DOLE. Right? Now, apart from providing for duties to employers, there are also duties, no, on the part of the employees and co-workers. Of course, to refrain from committing acts, discourage the conduct of harassment in the workplace, and provide emotional or social support to employees, co-workers, colleagues, or peers. And report acts of gender-based sexual harassment witnessed, no, in the workplace. So reports can be made, no, to the person or any agent of the employer, and such report should be sufficient notice on the part of the employer to refer it to the CODI. Liability, apart from the complaint, no, with the civil service in case of non-compliance of duties, is this one. Non-implementation of the aforestated duties can lead to a penalty of fine of 5,000 to 10,000 pesos. Right? Second, non-taking action on the reported acts of gender-based sexual harassment can lead to a fine of 10,000 to 15,000 pesos. So there's an admin aspect before the Civil Service Commission. There's also a criminal aspect by way of this law, no, before the courts. And importantly, there's an express provision stating that nothing shall prevent the victim from instituting a separate and independent action for damages. So meron ka ng admin, may criminal ka pa, meron ka pang civil action for damages. Just mainly because the employers did not perform their duties and not took action on the reported acts of gender-based sexual harassment. Just a stark differentiation between the two laws. No? Workplace harassment in 777, of course, generalized here, then specified. Authority, influence, and moral ascendancy were required in 777, 11313, none. No, peer-to-peer can happen. In fact, even superiors, no, can harass. So, a subordinate can harass their superiors. No? Duties of employer, dalawa lang. No? Like what I talked about kanina in the first part of this webinar, that there are only two. No? Creation of CODI and formulation of procedure. Here, expanded. Not only CODI, not only procedure, and many more. In 777, there are no duties of co-employees. In 11313, there are. Right? There are. And in 777, the penalties of the employer are not indicated. Hindi nakalagay. Pero dito, the penalties are indicated apart from the possible admin and civil action. Naka-specify po talaga. So we go to the last part, no, about gender-based sexual harassment in education and training institutions. I think this will be the last part. We will just continue next week. No? So before I proceed with discussing this one, kindly watch this video.
Isang pagsusulit para sa estudyanteng bago. Tama o mali, ito ang sabi ko. Ano nga bang pangalan mo, edad at kurso? Hindi ba ikaw yung laging sa dulo umuupo? Scholar ka pala, pero tagilid ang grado mo. Pero lagi kitang napapansin, para kang anghel na naging tao. Ang liit ng bewang at ang kinis ng mga braso. Masarap ka sigurong kayakap sa malamig na gabi, ano? Virgin ka pa ba? Wala pang nagiging nobyo? Nga pala, first name na lang. Huwag ka na mag-opo. May gagawin ka ba ngayon? Samahan mo muna ako rito. Bilan na kitang hapunan. Ano bang gusto mo? Mukhang gabi na. Wala ba sa iyong susundo? Hatid na kita pa uwi. Saan ba ang dorm mo? Medyo napagod ako sa biyahe. Papasukin mo naman ang iyong guro. Ang tahimik naman. Mag-isa ka lang ba talaga rito? Isara mo na ang pinto at halika sa tabi ko. Huwag ka na matakot. Hindi ako masamang tao. Dahil kung ayaw mo bumagsak sa pagsusulit na ito at gusto mong makakuha ng mataas sa grado, huwag kang aangal sa aking mga plano. At ngayon, pumili ka. Kwarto o 4?
Okay, thank you again for watching that video. Now proceed, no? So for gender-based sexual harassment in education and training institutions, it's very clear that there should be an OIC which shall receive the complaints. And in fact, no, if possible, there should be an office that should be accessible to receive complaints on gender-based sexual harassment. Now, this is The reason is, of course, to process the complaint efficiently, to provide immediate assistance, and to forward the complaints to the CODI, within 48 hours from a receipt therefrom. Now, the recipient again, same with that, and gender-based sexual harassment in private establishments. It should be, the person should be knowledgeable about gender-based violence, sexual harassment, mental health, counseling, and other relevant knowledge in handling these subject cases. There should be confidentiality in the process of accepting the complaint. Also, as provided for, that within 150 days from the effectivity of the rules, every education and training institution must adopt and publish grievance procedures to facilitate the filing of complaints. So I know most of you already have this, so it's just a matter of enhancing it, now with the new knowledge of the laws that we have discussed. Okay. All right. Now, institutions can have the right to strip off the diploma from the perpetrator or issue an expulsion order. And also the CODI, again, as what was mentioned, to be mandated to be created before education institutions, should address not only sexual harassment that happened physically, but also those happen online. All right. In accordance with the rules and procedures contained in the CODI manual. Duties of school head, same with the duties of employers, disseminate. Okay, bakit ko na po yan kanina. Also, provide measures by information campaigns, all right? Inclusion in the handbook, orientations, and the heads are also shall have the duty to ensure that they will receive age-appropriate GAD trainings. Now, for the CODI, it's just the same with the CODI in the workplace with the addition of the third one. That should be equal representation of persons of diverse SOGI in the CODI as far as practicable. All others are similar to the CODI in the workplace. Also, there's a mandate that the heads shall have a code of conduct or school policy which contains these minimum requirements. Liability, same with what's provided for employers, an implementation, fine 5,000, 10,000. Failure to act on reported acts of gender-based sexual harassment, 10,000 to 15,000 pesos. Same that these liabilities shall not prevent the filing of admin cases against the school with the appropriate disciplinary authority. Miss Sasha, i-park ko muna. So, tapusin ko na to. All right, students. Now, if they're students, of course, they should be liable to gender-based sexual harassment based on their sanction on their school handbook. So, difference between training or education-related sexual harassment in 777 and 11313, somehow, katulad din po ng differences kanina. Okay, ang kaibahan lang po dyan because in 777, the requirement for CODI and Code of Conduct was generally stated, where here, it's very clear that the CODI requirements are specified apart from the Code of Conduct, which shall be present alongside the existence of the CODI. Okay, so let me answer the question of Ms. Sasha. If the harassment occurs during the course of OJT of students, would the CODI of the institution have the reins to deal with the case? The answer is yes. In fact, this specific provision can be added to your code of conduct or your policy. And ito yan, sa code of conduct na yan, pwedeng ilagay dyan. Anyway, I will discuss this later. I will just want to show you here. Okay? So OJTs can be added in the code of conduct. It's just not a mandatory word, but it may include. So it will depend upon the institution. But it should form part of the code of conduct to cater these kinds of scenarios whereby OJT students will be able to seek redress or relief in case that they will be subjected to sexual harassment incidents. Now, okay, if it is not included, to answer your question, it would appear to be that there will be no way upon which the students here will have to be able to attain their justice here. So I think it will go with the existing contract with the institution as to the partner agency which provides for the CODI. So if there are penalties or liabilities provided in the conduct, then there can be redress or relief based on that contract entered into before the agency and the institution. The only way that the CODI will be able to reach, no, the agency where the OJT happened is by way of including it, no, in the code of conduct. Miss Ermelina, if verbal sexual harassment is done in the workplace, but then nobody will witness like what is happening in the video, will it be accepted in the court? This will be accepted, no, but we must take note that not only a witness can be your evidence, no. Again, like what I was mentioning, there are other kinds of evidence which can be support or enforce your complaint, no. This is only one kind of evidence, yung testimonial evidence. There's documentary evidence or object evidence. Okay, so one kind of evidence for verbal sexual harassment is that, no, to establish whether that act happened on that same time, place, or date. All right? So kapag na-establish mo 'yon, no, konti na lang, mapoprove mo na yung pangyayari. Kasi pag wala ka talagang witness pag verbal, medyo mahirapan ka. But there can be other corroborating evidence and that can support your claim. Like for example, establishing your presence there before or after, okay? Or other preparatory acts prior to the verbal sexual harassment act. Diba? So baka dun sa mga preparatory acts or post acts after the sexual harassment, the verbal sexual harassment incident, baka dun ka makakuha ng witness for that matter. Diba? Kasi alam ka namang isang beses lang sinabi sa'yo yan, baka there are chances whereby, no, these things already happened before or in preparatory to that verbal sexual harassment act. So again, there can be documentary object evidence also can be utilized, not only testimonial evidence, and also there can also be testimonial evidence before the incident or immediately after the incident that you can be utilized for filing the case. It can be accepted by the court, but I think the issue is that will it have a chance of being elevated, or will it have a chance that the accused will be convicted if you will be providing the evidence that I've mentioned, there can be a chance that it can be elevated before the courts or that the accused can be properly prosecuted. Okay, Ms. Sasha, it would be very helpful that during the crafty. Yes, exactly, no, because without the mention of that in the code of conduct, no, we can only rely with the contracts or agreements that we have between other partner institutions, whereby we have interns, we have OJTs with that matter. In fact, same would also go to the concessionaires. Now, I think most of our schools or HEIs also accommodate concessionaires in our premises, whereby if they commit sexual harassment acts, there's no recourse. So I think the proper recourse is, number one, put it in the code of conduct, and second, put stringent devices or measures in the existing MOUs or MOAs given in that that can cover these agencies that are part, no, of the academic institution. Okay, so I think I'm over time. I was not able to finish our discussion for today, but I promise you that I will end our discussion here. But before I leave you, I actually have an assignment, no, for all of you. Hindi pa po tapos. Okay, just allow me to share to you my assignment. We have so many pa to talk about. But for our assignment, no, okay, for the HEIs present, no, if you are belong to our partner agency, you can do this also. Wait lang, I will answer this question. Ay, wala na palang question. Welcome po from Medina Foundation. So assignment, based on the laws discussed, we have discussed the laws, the latter parts of 11313 are the ones that are remaining. So basically, substantially, you have discussed 11313. So based on the discussed laws, formulate 8 provisions, no, that you would want to be included in your respective school manuals. I think one of the reasons why we have this webinar is for you to be able to incorporate or institutionalize what you will be learning. So apart from providing the provisions, you indicate the legal basis or reasons for each of these provisions. Now for next week, you should prepare a PowerPoint presentation. Siguro one for each institution na lang, containing the provisions with basis. It will be presented on a given schedule on June 14 so that we can properly comment. Now, para naman ma-motivate kayo, okay, the HEIs who will be able to submit will win a prize coming from me. Okay? So the prize will be announced on June 14. Okay? So hopefully with the discussion that we had today, although it's only for 4 hours and I wasn't able to finish the latter parts of 11313, somehow you were able to be, you were enlightened, and you were encouraged to add the specific provisions to your existing school manuals. So hopefully we will be able to participate in this exercise, so that we can learn from each other, and also I can input somehow on this PowerPoint presentation we will be making. Okay, so again, I promise to continue on the Code of Conduct and CODI on June 14. All right. Okay, sige po. So I will stop share. So it's a pleasure to have lectured to all of you this afternoon. I'm very happy to have lectured to all of you, and I'm very, actually, I was amazed with the conversations and discussions we're having. So kasi I strongly believe that in these kinds of webinar, it's very important to have discourses about these things for proper learning. Hindi lang yung laging sa akin. So mas maganda yung nag-uusap tayo. So I encourage more participation on Monday. Okay? So kanina 230 tayo, ngayon 167. Pangit ba ito na pangitain? But hopefully the reasons again are not because of the speaker. Okay, with that, maraming salamat po. I hope to see you on Monday. I'm giving the floor to Miss Queenie. Ingat po kayo. Stay safe. God bless. Maraming salamat po.
Thank you for that. A very insightful talk po, Attorney Eric. I'm sure all the 167 participants dito sa Zoom meeting, tsaka yung mga viewers na andun pa rin nanonood sa Facebook would agree that this has been a very informative na training. And as much as we want to entertain a few questions during this open forum sana, we are short na sa oras. So you may, however, email your questions to MSU-IIT GAD Resource Center. So we'll share the email to that. Can the tech team perhaps do that? That's ovcre.gad@g.msuiit.edu.ph. I'm sure the tech team will be typing in and we'll send that now. We're going to compile the questions and we'll send it to Attorney Eric tomorrow so that those can perhaps be addressed live on next week's session. Pwede po ba yun, Attorney?
Yes po, actually I encourage more questions coming from our participants.
Ayun, sige po. Thank you po. And those who'd like to benchmark as well MSU-IIT's practices and processes, as mentioned by CHED Regional Director Alvarez in his speech earlier this afternoon, you may also send an email to that very same email, ovcre.gad@g.msuiit.edu.ph. GAD, the Resource Center, would be very happy to do that. Thank you again, Attorney Peralta, Attorney Eric. This has been a very enlightening and engaging discussion. And thank you also to the very participative na mga audience this afternoon. As a way of synthesizing, Attorney Eric detailed the acts that are considered as work-related sexual harassment, education-related sexual harassment based on RA 7877. And in extension, we talked about CHED Memorandum Number 1, Series of 2015, which included, apart from the sexual harassment acts under RA 7877, other related sexual offenses were also discussed. We also talked about 2017 RACs, where Attorney Eric emphasized that even the accomplices will be held liable apart from the perpetrators. The composition and functions of CODI were also discussed on that specific na policy and how the authority, influence, and moral ascendancy will not matter under 2017 RACs. Another important point raised earlier is on how HEIs are encouraged to not only address or provide remedy through CODI on acts of sexual harassment and other sexual offenses, but that HEIs are also encouraged to provide other assistance such as guidance and professional counseling. We also talked about RA 11313, the acts that may fall under gender-based streets and public spaces sexual harassment, including those done online in public spaces, in vehicles, and in the workplace, all of which that are punishable under RA 11313. A participant reflected on how one must be careful of his or her actions while listening. And apart from that, it has been emphasized that under the new law, CODI head must be a woman and that not less than half of the CODI members should be women. So that concludes our first training session on this two-part training on Appreciating Committee on Decorum and Investigation, Anti-Sexual Harassment Act, and Safe Spaces Act. Thank you so much for spending your afternoon with us. Thank you most especially to Attorney Eric. And on behalf of the Gender and Development Resource Center of MSU-IIT, Commission on Higher Education of Region 10, thank you to everyone for tuning in. And please don't forget the assignment for next week's training. May prize po ito, so it's something we can look forward to next week. Also, please do follow the Facebook page, Gender and Development Resource Center, MSU Iligan Institute of Technology, to keep posted on the details for the second session of this two-part training, as well as the other gender-related webinars that we are conducting. So to give feedback po on today's session and to help us improve as well our next session, please complete the evaluation forms for the event and also for the speaker. In addition, please also complete a post-test. So the completion of those three forms, the post-test, evaluations for the event, and for the speaker, will be the basis for the giving of e-certificates, as well as the materials, which will also be sent along with the e-certificates. So that will be the materials for this session, which Attorney Eric has kindly provided, and the materials for the second training session next week. So please note that the certificates will be issued after 2 months, and that the links are now shared on the chat box. So you may now start copying those links, and you may answer that after you log off the Zoom meeting. It is a...
May nagre-request na i-share ulit yung yung assignment. Pwede ko bang ipakita ulit?
Yes po. Sige po.
Alright, so this is the assignment for next meeting. No? Hopefully, you will be able to screen cap na lang po siguro. This is not part of the presentation that I sent to MSU kasi surprise ko dapat po ito eh. So, ayan po, paki-screen cap na lang po ito. And hopefully, at sana po all ay mag-participate. Okay? So, thank you po.
Yes po, and I've also screenshotted that and I will send it to the tech team po para ma-remind rin po yung mga HEIs, and that might be sent to them as well later today or tomorrow so that they could prepare. And it has been a great pleasure po moderating this session. So thank you so much and see you in the next part of this training. Daghang salamat. Maayong hapon sa tanan. Stay safe. Thank you again, Attorney.
Maraming salamat po sa lahat. Maraming salamat, Miss Queenie. Ma'am Nats, maraming salamat po. Ingat po kayo.
Thank you, Attorney.
Maybe we can take a picture siguro po.
Sige po.
Ayan. So for those who are still with us, you're welcome to have your cameras on for a quick photo opportunity.